Good morning to you all. Mr. Siminya.
Good morning, Chair, and to the commissioners. Today we have Advocate McAdam coming to help us further. He is assisted by my learned colleague, Mr. Bana, and I take it to place on record that Mr. Vani will do whatever questions he has to do virtually.
Yes, yes. Mr. Bana.
The Chair, with Ms. Mshizana, instructed by the State Attorney for Mr. McAdam.
Thank you.
Thank you. Good morning to all of the commissioners.
Who is going to start between Mr. Vani and Ms. Rantu?
Chairperson, Ms. Runter requested that she go first this morning, and Weaver consented to her request.
Thank you. Advocate McAdam, you are reminded that you are still under your former oath.
Correct, Madam Chair.
Thank you. Ms. Ranto, you may proceed.
Thank you, Chairperson. Good morning.
Good morning, Council.
Advocate McAdam. My surname is Ranto. I represent the South African Police Service.
Certainly. Pleased to meet you.
Now, if I may start with you, at paragraph 23 of your affidavit that you filed with the Commission, it must have been in March this year.
Right, I've got it in front of me. I'm just turning to paragraph 23.
23, yes. It's just to confirm that you informed the Commission that that's the time when you joined the PCLU, correct?
Sorry, can you just repeat? It's paragraph 23.
23, yes.
23?
That's,
I've got it, yes.
Yes, paginated page 236 of the Galata Cross bundle.
Fine. I have it in the inquiry bundle at 1400.
Thank you so much. What is indicated is that you joined PCLU after being so invited by Advocate Ackerman in May 2003, correct?
That's correct.
Now, what I want to find out from you, what was your understanding of the PCLU's mandate at the time?
Madam Chair, the PCLU was established as a special directorate which is provided for in the NPA Act. The Act enables the President, on the advice of the NDPP and the Minister, to appoint special directors for specific purposes. The Act does not say how many the President may appoint, nor does it specify what duties they will perform. But it is clear, Madam Chair, that that provision in no way made these special directorates investigating agencies. That falls under a completely different section of the NPA Act, the Section 7, where provision is made for investigating directorates. And when the DSO was established in January 2000, a special Act of Parliament was passed, Act 61 of 2000, which specifically empowered the investigating directorate to perform policing powers, full investigative powers, without the investigating officers being police. So this was an elaborate piece of legislation because they had to now confer all the police powers to a non-police agency. And with the PCLU, the President issued a proclamation where he defined our terms of reference. Now, that proclamation listed offences which fall within the ambit of state security, and I can explain why he did that. Firstly, I think it was about 2001, the country was gripped in a serious wave of right-wing domestic terrorism. You had well-trained terrorists targeting the community in greater areas of the country. They planted bombs in bus stations, taxi ranks, killing and injuring innocent people and children. In Bronkhorstspruit, there is a Buddhist temple which they blew up, believing it was a mosque. They even went so far as to work out when President Mandela was visiting his home in Transkei, he would be going over a bridge and they would blow up the bridge and kill the president. And what had happened is the state realized that they were still addressing terrorism in terms of the old security branch legislation of the 1780s, and that was totally inadequate. So this is why the president then said, we will now deal with terrorism in terms of new democratic processes, because one of the first things that the PCLU did was to contribute to the passing of a new terrorist law, the protection of constitutional democracy against terrorist and associated acts. So that gave us extensive powers, while at the same time doing so in the course of human rights, which was absent from the apartheid era terrorism laws. South Africa had just ratified the International Statute of Rome, which created the International Criminal Court. Now, as a result of those obligations, South Africa was not only obliged to assist the International Court with investigations, but it was required to have domestic law to deal with crimes against humanity, genocide and war crimes, which fell outside the mandate of the International Court. So it was expected that we would be the world's policeman when the International Criminal Court. And I mean, that required very experienced prosecutors, because those crimes have very complex elements. They're not easy cases to prosecute and get convictions on. As well, Madam Chair, South Africa had a grip of former combatants, not only the security forces, but also ex-MK members, either forming mercenary groups like Executive Outcomes, or being hired by foreign governments to render mercenary activity, in some cases even being hired to overthrow sovereign governments. So the President referred the mercenary legislation to the PCLU, and lastly, the Act made provision that the President could also assign other priority crimes that were not in the proclamation. But the proclamation definitely did not turn the PCLU into a fully fledged investigation unit. The PCLU was dependent on the two law enforcement agencies, SAPS and the DSO.
Thank you, Advocate McAdam. Now that you have addressed the Commission at length regarding the proclamation, may I refer you to page 68 of the SAPS cross bundle. That's the proclamation. Page 68.
That's correct.
Yes.
I confirm this is the proclamation that was issued.
And that's the one that you were just referring to earlier.
That's correct, yes.
Okay, now if I may, request you to just read into the record where it starts off by to exercise powers. Or maybe just for the sake of completeness, if you can just say, start reading from determination of powers, and then you proceed up to paragraph A, paragraph A of the proclamation.
Correct. Then starting with that, to exercise the powers, carry out the duties, and perform the functions necessary within the Office of the National Director of Public Prosecutions as directed by the National Director, and in particular to head the Priority Crimes Litigation Unit, and to manage and direct the investigation and prosecution of crimes contemplated in the implementation of the Rome Statute of the International Criminal Court, Act 2002, in brackets Act 27 of 2002, and serious national and international crimes, which include acts of terrorism, sabotage, committed under the Internal Security Act of 1982, Act 74 of 1982, high treason, sedition, foreign military crimes committed by mercenaries, or such other priority crimes as determined by the National Director. B is to generally giving such advice and rendering such assistance to the National Director as be required to exercise the powers, carry out the duties, perform functions which are conferred on or imposed on him in terms of the Constitution or any other law.
Thank you very much. Now, in respect of paragraph A that you just read out, I just want to get your understanding in terms of the responsibility given to manage and direct investigation and prosecution of crimes. What did that entail?
Madam Chair, that meant that we would manage or direct investigations which were being conducted by the two law enforcement agencies at the time. It in no way conferred any power that the PCRU could become a police force and start performing police powers. In this regard, Madam Chair, I refer the Commission to the section in the MPA Act which deals with the powers and duties of the directors of prosecution who sit at the seats of the high courts in the country. They are empowered to coordinate, supervise, and direct investigations. But again, it cannot be argued that the Director of Prosecutions in Johannesburg is now a Commissioner of Police. His office can go out arresting people, carrying out searches, setting up roadblocks, shooting dead suspects in armed robberies, etc. All it means is that the MPA will guide and direct investigations. That is consistent with international best practices, namely that you have prosecutor-guided investigations. That is standard in all countries that have proper functioning law enforcement agencies. We've interacted on numerous occasions with our counterparts across the world, and it's the same story. You will not get the District Attorney of the United States going and arresting people and searching. That is the function of the FBI. The FBI arrests and investigates, it doesn't prosecute its cases. Similarly with Britain, you have the Metropolitan Police, but you also have the Crown Prosecution Service. So it in no way transferred the investigation of powers from the police to the NPA. That would have required amending the NPA Act, the Police Act, as well as the Constitution, because the Constitution places the responsibility for investigation of crime on the police and not the NPA.
Thank you. I'm going to make a request that when I ask the question that you try and keep your answer quite short, because I'm going to end up losing each other. I wanted to understand, by managing, what was your understanding, management of investigation? What exactly did it entail?
Madam Chair, it would be that I could give guidance to the police and monitor the investigation. So the police would come in with a docket, I would read it, I'd say, these are your further investigations written out, please conduct them. I would then monitor the investigation to decide when is it complete, when would it be appropriate to arrest, would it be appropriate to conduct a search before. And that would be the sum total of it. At the end of the day, you'd read the docket and make a decision to prosecute or not.
So in this case, you informed the Commission that at that time, you had members of the police that were reporting to you regarding those investigations.
Madam Chair, there is, as I said, we're not an investigative agency. So where there are crimes falling with the ambit of that proclamation, they would be investigated by the police, and those police officers would then report to me for the prosecutorial guidance and nothing more. At the time, the police had a crimes against the state unit which mirrored our mandate. So when cases of those matters came in, they would be investigated by the police and they would come to us for direction guidance.
Maybe if I may just ask a specific question. At that time, when you joined PCLU, which members of the SAPS were reporting to you in relation to these investigations?
Madam Chair, at that stage, if I recall, this is now 2003. We had just started. So I don't think any police officers reported to me. Dr. Pretorius was at that stage engaged in a number of mercenary-related cases. I stand under correction, but I think those cases were a shared responsibility between the police and the DSO. So he was then, if they were investigated, if some of those cases were investigated by the police, they would be reporting to him.
So that investigation, as you say, or whoever police officials were involved would have reported directly to Advocate Pretorius?
No, Madam Chair, they would report to him for guidance on the investigation. They would be primarily responsible to their commander. He would be the person who would allocate the investigation. He would monitor, are the police complying with the prosecutor's directions, and he will render a lot of support to the police which fall outside of our capability.
Evidence,
So this in no way absolved the police commanders from their own responsibilities to make sure the investigators do their work.
evidence before the commission is that during the formation of the DSO, there was secondment of members of the SAPS who were housed with the NPA, performing investigative functions, reporting to the NPA. Secondment, meaning they were housed with the NPA. To be specific, there was a senior superintendent, Henny Bretz, and Director Nell. And that's why when I wanted to understand as to who specifically you were dealing with, I wanted to understand,
Madam
was
Chair-
it those ones or any other policemen?
No, Madam Chair, Mr. Britz, Henny Britz, and there was a brigadier whose work were in no way seconded to the MPA. What happened is, in 1996, Commissioner George Fibers gave an instruction that all the cases that the police had investigated against the armed wing of the African National Congress be brought to Pretoria and to be available. So all these cases would be available at one point, and they would, when the TRC needed to see police dockets to verify amnesty applications, they only had to go there. They didn't have to go all over the country trying to get dockets from localized policemen. Brits and the brigadier were ex-security branch members. They were given contracts on retirement by the National Commissioner to discharge that function. So the interaction would only be that where the MPA needed to access those documents to make decisions, or where the Brits and the brigadier said, there are matters that need investigation, can you give us the directions? But they were in no way working with the DSO. And while they were, what happened is there's a shared responsibility. They were given accommodation in the office of the DPP Pretoria because Advocate Fick had done a number of cases against the ANC, the Delmas trial and other key cases, so he would be in close proximity to the police officers to deal with any requests. And in the same way, Madam Chair, the former De Oliveira unit investigators who investigated the cases against Eugene de Kock, Botha-Basson, they were also housed in the DPP's office to have close proximity to the Attorney General, Dr. De Vera, and his prosecution team. But in that, in no way changed the fact that they were police officers and the nature of their duties. It simply, it makes sense on complex crime for MPA and police to sit together so we can move quickly and efficiently.
Thank you, Advocate Pretorius. Now, perhaps if I may refer you to paragraph 29 of your affidavit. That's page
Not
2.
Advocate Pretorius.
Advocate McAdam. My apologies, Advocate McAdam. Paragraph 29. Now, you informed the Commission in terms of that paragraph that Advocate Ackerman submitted an internal memorandum to the NDPP, Mr. McCarthy and Dr. Ramaite, and the Deputy National Director of Public Prosecutions. Now, of importance in that paragraph is that there was a proposal made to transfer Mr. Fix cases to the PCLU and those handled by Dr. Pretorius from the DSO also to be transferred to the PCLU. It also proposed an office structure that included secondment from DSO headquarters of 6 investigators to conduct identified investigations. Now, if those investigators were to be seconded within the PCLU, but the PCLU did not have investigative powers, what purpose would that serve?
Exactly, the execution of joint prosecutorial and investigative powers. These investigators were not policemen. They were fully fledged DSO members who were conferred with the same powers as police officers. So if they second them to us, then they're working directly with us. We can directly task them. They don't have to be distracted with a whole range. They work full-time on these cases and not other matters. And that is nothing different than what happens with the police. I, for many years, worked on the political violence, and there were special police units that were set up to address that violence. And the arrangement was that between the National Commissioner and the DPPs, the prosecutors and investigators would be housed in a separate building because there were high risks of witnesses being seen going to the police station or going to the DPP's office, and we'd work together in the same building as a team, but not usurping each other's functions. That was extremely efficient. If an informer phones the policeman, says, I've got information about an arms cache, he can walk straight into the prosecutor's office and say, I've received, what do you advise? Should we go ahead and do a search? Should we do some monitoring first or whatever? And that happens standard. I was, after retirement, given a 3-year contract with the Investigating Directorate Corruption. Now, before it became IDAC, there were seconded commercial branch police officers that were doing our investigations. We were all working from the same building and in direct and daily contact with each other.
On the same note, during your interaction with Mr. Nduka, you informed the Commission in the same paragraph that a request for secondment of the investigators was declined by Mr. Nduka, correct?
Yes.
And you also informed the Commission that Mr. Nduka said that that responsibility lied with the DSO, correct?
He declined the secondment, but he didn't say that the DSO will not investigate the cases that we had identified and presented to Mr. Nduka. Obviously, if they are seconded to us, then Advocate Ladwaba, who is the investigating director, wouldn't be able to assign other investigations to them. So probably with resource constraints, it would say they will help us, but not working directly under our command.
Yes, but in paragraph 30.3, if I may just remind you, you stated that the request to second 6 DSO investigators to the PCLU was not approved, but Mr. Nduka made it clear that the investigation should be conducted by DSO members.
That's correct.
And there was no mention that it should be DSO members with the SAPS, correct?
Correct, Madam Chair. What had happened is the police were at that time only focusing on the 400 ANC cases. There was already a brigadier and a colonel managing that process. But as far as the cases against the security forces were concerned, these had been the responsibility of the De Oliveira unit, and that had dissolved.
Sorry, Mr. McAdam, I don't mean to be rude, but again, I think my question was just, it was pointed that in that paragraph, what Mr. Nduka made it clear was that investigations should be conducted by DSO members, right?
Yes, that's correct.
Yes. Can we just leave it on that note for now, and then we'll engage further in relation to the involvement of the police at a later stage. And then, as you said in paragraph 24, of your affidavit, you said PCLU lacked investigative capacity. And can you go to paragraph 24?
That's correct.
Yes, and as you say, they would have to rely on the DSO and the DSO.
Or the
And-
police.
Yes, or the police, yeah. And then just perhaps to get your comment on what Advocate Ledwaba said when he testified before the commission, to say that his understanding was that the PCLU was clothed with investigating powers. Now, if I may just, for the convenience of the commission and everyone, Advocate Ledwaba's affidavit appears on the master bundle, page 1708, specifically those paragraphs 43 and 44. But essentially what Advocate Ledwaba informed the commission was that his understanding was that you were clothed with investigating powers. Your comment on that one?
He is incorrect. He has obviously not read the NPA Act, as well as Act 61 of 2000, which created the DSO, and he clearly does not understand the difference between an investigating directorate and a special directorate.
Okay, thank you. We go to paragraph 25, where you referred the commission to a memorandum detailing audit of cases that you handled while at the DSO, correct?
Sorry, my paragraph 35. Is it the-
25, 25, sorry, 25.
Yes, I have it now.
Yes. Paragraph 25. Now, you informed the commission about the audit of cases, or that you conducted of cases that we handled while at the DSO, correct?
That's correct.
Now, I need to get your understanding. In the same paragraph where you stated that the audit sets out ready to proceed to prosecution, provided investigations were finalized, as well as cases identified for investigation, including the Timor case. Now, what I need to understand is, what did you mean by the audit that entailed ready to proceed for prosecution, provided investigations were finalized?
Madam Chair, there were clear cases where, for example, persons had been granted amnesty, found to be excellent witnesses by the TRC, were willing to testify against those who had not applied. But before you could have the prosecution, you would have to do further investigations and go much further than the TRC did in its amnesty committee. And there were other cases as well, Madam Chair. There were cases where there had been successful prosecutions, people convicted, and there again, you could use the witnesses, you could then use that as a basis for prosecuting the other people who had not been charged at the time.
Perhaps if I may just understand, why would a case be ready for prosecution when there's a need to investigate further?
Because you've read the amnesty, the judgments of the court. In some cases I had, when I was at the TRC, dealt with these witnesses, and you know they are good witnesses, and all you need to do is now conduct the necessary investigations to have a bulletproof case where you can prove your case beyond reasonable doubt.
But you can accept that until that has been done, the case cannot be ready for, to proceed for prosecution, right?
No, but you already, as you are directing, starting to work on drafting your indictment, doing all your prosecution arrangements, because the only reason that it won't be prosecuted is if your witnesses died before the time or the accused died. But there's nothing wrong at an early stage of saying, do investigations, because there's clear cases to prosecute. I've done terrorism cases where the police have come into me and said, look, this is the information they have, and this is the first time we met. I said, well, look, on this alone, we are going to get them, but now we need to get the search warrants, all the other investigations. So you don't say, I don't even look at whether we can prosecute until we have a full, it would be counterproductive. You get involved prosecutor guided at the first instance you can.
Your selection of words, you said ready to proceed. And from what you explained, you would have investigated, and in your example, by obtaining such warrant, that means until you've obtained such warrant, the investigation or the matter cannot proceed for prosecution, isn't it?
No, Madam Chair. Let me give you an example. The one case that I listed was the prosecution of General van Rensburg on the Motherwell bombing and the Brian Ingalunga case. In those matters, when it was before me, there had been a full investigation, there had been prosecution where people had been convicted, there had been amnesty applications where people who would be very good state witnesses had been granted amnesty, the people we wanted to prosecute had been refused amnesty. So you had this huge wealth of material. So as the prosecutor, you go through it, and then you identify the following further steps that are necessary, because you have gaps. We're looking 2003, the amnesty process, 97, 98, the criminal investigations earlier. So you need to check, is the evidence still there? Has some of it not available? But also, did people in the 1990s sit the matter out, but they would now come forward seeing that you can be convicted if you don't cooperate?
Thank you. Let's stop off that point and deal with what you informed the Commission about transfer of 400 dockets to the SAPS. Remember when you testified during your evidence in chief, where you informed the Commission of a number of 400 dockets that were transferred from the NPA to the SAPS. You remember that?
Correct, Madam Chair.
You also recall that you informed the Commission that those dockets would be kept with SAPS pending direction on further investigation from you. You remember that?
No, Madam Chair. What happened is there was a very unpleasant incident where the National Commissioner of Police accused Mr. Nmuka at a high-level government meeting of preparing to investigate the President and 6 other prominent ANC officials.
Sorry, Advocate McAdam. I don't want us to get into the reasons of the transfer. I wanted to understand what the status was.
The status was, as a result of that allegation, because Celebi alleged that the reason those 400 dockets were in the MPA building was to compile this case against the President and these other people. Mr. Nmuka then invited Mr. Celebi to come to the DPP's office, remove the dockets. Mr. Celebi did not appear. Deputy Commissioners Williams and Price arrived. Mr. Nmuka said, fine, this is the allegation, you take those dockets. So you can no longer make false allegations against the NPA. But Mr. Nmuka said, the only reason that those dockets come back to the NPA is if you, the police, say you need assistance from the NPA. If you don't need assistance, they stay where they are, but we're not closing the door on cases that could be prosecuted, but we put the ball back in your court. You come and tell us where you need our assistance.
So the dockets were housed at the NPA, correct?
That's correct, because the 2 police officers who were working with them were given accommodation in the DPP's office.
And who did they report to? To the
To-
National
to-
Commissioner of the Police?
To whoever in the police appointed them. I don't know if they were reporting to Commissioner De Beer, the divisional head of the detective service, or to Commissioner Celebi, but I know the arrangement was done by Commissioner Favers, who was then the National Commissioner.
Evidence before the Commission by General Williams and General De Beer is that those police officials were housed at the NPA, they were reporting at NPA, hence they were seconded, meaning they were not accountable to the police insofar as their work was concerned, but rather to the PCLU.
Madam Chair, we had no dealings with these. This is a long time ago. I have to think about this. When those dockets and those 2 policemen arrived in the DPP's office, Advocate Fick was in charge of them, but purely from a prosecution perspective. Now, when the PCLU was established, it was decided that all the PCLU cases should come to the PCLU, so you have only one unit dealing with these matters, not two different officers. And what happened is then Advocate Ackerman said, I will start reading those dockets and writing up whether they can be closed, whether they need to be prosecuted, etc. And that process was interrupted by the decision to send those dockets back to the police. So, and in my dealings with the Brits and the Brigadier, they were no support reporting to me. All I would do is ask them, I need to see if there is a case against the President. Would they show me their register? Would they draw certain of the dockets listed there so I can check whether I'm right if I say there is no case or not? And all they did was bring the Blarney case to our attention, say the suspect is now back in the country and would we look at, but they were not under our command. It was simply the normal relationship of police officers and prosecutors working in close proximity, but within their own mandates.
Now, if who was in custody of those dockets? Was it NPA or the SAPS?
SAPS, Brits and the Brigadier.
If it was the SAPS that had custody over the dockets, why would Mr. Nguka order that they be transferred to the SAPS?
Because he wanted to prevent Commissioner Salebi being able to further allege that the reason those dockets were at the NPA was to manufacture this case against the President and the other prominent government officials.
Now, your evidence is in total contrast to what Advocate Ackerman said, because his evidence is that in May 2003, the then NDPP, Mr. Nguka, made a determination that all TRC-related cases in which amnesty had been denied or not applied for were priority crimes in terms of the proclamation. And I think we agree, it's common cause. You also agree to that, isn't it?
But if you can make the reference to where Mr. Ackerman said it in the record.
The affidavit dated 20, I will come back. It's the affidavit dated 2015, Commissioner Homo. We'll get to that one, affidavit of Ackerman. But nonetheless,
yes,
yes, I am mindful of that. Thank you, Commissioner Homo. Chairperson, that would be paragraph 14 in the Nkadibe matter. That's now Galata Bundle 3. That would be paragraph 14, page 5 of Galata Bundle 3. Page 5, that would be page 5 of the Galata Bundle 3.
Thank you.
But then let's proceed in terms of the transfer, Advocate McAdam. Your version is that these were in custody of the police, even though they were housed at the NPA.
That's correct, Madam Chair. My access to those dockets had to be through the two seconded police officers.
Advocate Ackerman, in his affidavit, he stated that this resulted in more than 400 investigation dockets being transferred to the Ackerman's office. That's now when you were moved from the DSO to PCLU. That dockets were transferred to Mr. Ackerman's office.
Madam Chair, that is simply for prosecution purposes, that Mr. Advocate Fick was relieved of his duty of being the prosecutor in charge. The responsibility now moves to Mr. Ackerman. So Mr. Ackerman had, before he was made the special director, been a deputy director in the Pretoria office. When the PCOU was established, we did not have office space. He remained at his old office, and all he did was to ask the two investigators to place dockets before them. He would read them, and then he would type up an office note saying what the facts of the case were and what his decision was. And those office notes were then put on the police docket so that the police could see what the position is. It was the responsibility of the police. All finalized matters would have to closed off by them. not the NPA.
Advocate Ackerman further stated that Advocate Chris McAdam, attached to his office, conducted the initial audit and identified 21 cases as worthy of further investigation.
Madam Chair, those were the dockets that were originally with the De Oliveira unit, which Mr. Nguka had decided must be a DSO responsibility, and not the police dockets.
So there were dockets with the NPA.
There will always be dockets with the MPA. We could not do our work without dockets where we can read the evidence, make decisions, give guidance. If anybody walks into the DPP's office down the road, in almost every advocate's office will be piles of dockets. There's nothing sinister or unusual or untoward about it.
So the 400 dockets that were transferred to the SAPS were never in the custody of NPA, but they were in custody of the SAPS.
They were. All that happened is the MPA provided accommodation for those 400 dockets and for the two police officers who were in charge of them.
But if it is so, why did it have to be Mr. Nguka that said, because you are accusing us, take the dockets?
Because of the allegation by Commissioner Salebi that those dockets were being used to manufacture this, to lend credibility to the false claim that Mr. Nguka and the PCLU were planning to arrest the president and these other prominent officials.
But why would he bother to cause a transfer of dockets that were not his, or were not under his custody?
To prevent any further allegations emanating from Commissioner Salebi.
Ms. Ranto, you remember the witness was still explaining that part when you said to him he did not have to go that far.
Thank you. Yes, Commissioner, sorry. My apologies, Advocate McAdam.
Madam Chair, may I add, and it's important that we note this, had it not been for Commissioner Salebi, then Advocate Ackerman would have continued to read all 400 dockets, written them all up, and we would have then taken a decision as to whether these cases go back to police closed, or whether there are cases that need investigations and prosecutions.
If I may ask, did you ever have a sight of those dockets, the 400 dockets?
I have had sight of certain of them because I was tasked by Mr. Nguka to establish if there is any credibility to this allegation. What I did is I could, in the time, because Mr. Nguka said this is causing huge problems and ill feelings and tension in government, I need it dealt with quickly. I couldn't read 400 dockets. So what I did is I took the police register. It listed the police station reference, the charge, and then the outcome of the case. And these were either amnesty granted, convicted, or sentenced, or undetected. So what I did is I asked the police to do spot checks for me, that I would say, okay, case number 5 says amnesty granted. Can I see it? And you say it's a tear. They draw it, I perused it. Yes, the register is accurate. So in that process, I went through not 400, but say 20 or 30, confirming that that register was correct, and therefore I could rely on the register for the basis of my decision. Advocate Ackerman did read, estimating between 65 and 95, where he wrote up on each of them.
If I may just ask maybe from you, at whose behest were those dockets opened or registered?
The
At
police
whose
dockets.
behest? Yes.
The South African police who were responsible for those investigations when the crimes were committed. When a bomb goes off in the middle of Joburg, killing a whole lot of civilians, they immediately open the case.
So
when there's a landmine planted on a road and blows up a car with civilians and their farm workers, they open the case, they investigate it, and they only really stopped with the amnesty process because you could not commit extensive resources to investigating cases where everybody is going to get amnesty.
Advocate McAdam, I think we have common understanding in the normal course, the police or crime would be reported to the police. Is that not so?
And the police detect these
In
things.
the normal course?
No, Madam Chair, there is no normal course. If somebody assaults me in the street,
Yes.
I have to trigger that. But the police monitor crime trends. If they pick up on their own there is terrorist activity, drugs are
Sorry,
coming.
sorry.
They will, of their own initiative, do the necessary police operations. They are not dependent on a member of the public saying, please investigate this case.
Advocate McAdam, let's go back to basics. I'm trying to
I'm
understand.
giving you
and
the
follow.
basics, sorry.
Yes. Give me the basics, but let's find each other. Let's be on the same page. The question is, in relation to the 400 dockets, the police, as you say on your version, they opened those dockets, isn't it? Because NPA, as you say, you don't register dockets as NPA, or you didn't register as dockets as NPA, correct?
Madam Chair, no, we did not open dockets.
So, these 400 ones, at whose behest were they registered or opened, these dockets that we're talking about?
They were registered by the police, who were responsible for investigating crimes against the military wing of the ANC during the 70s, 80s, and 90s.
Okay, so the PCLU was not involved in the
We were not
opening
even
of-
in existence then, Madam Chair.
I beg your pardon?
I said we didn't even exist then. We only came into existence in May 2003.
Correct, yes.
The
I'm trying.
400 police dockets were
Yes.
all opened before 1996, relating to the political violence that took place in the 70s, 80s, and 90s.
All of them.
That's correct.
Now, evidence that was put before court by Colonel Coetzee, the affidavit of Colonel Coetzee, chairperson, is in the Coetzee bundle. Apologies, commissioners, I just want to get to. It's paragraph, would have been paragraph 17 of Coetzee bundle. It would be page 6 of the bundle of Colonel Coetzee. Do you have it in front of you there?
I have this document. I'm just paging through to
Okay,
see
so it's not there.
if it's here.
Okay. Be it as it may, it's not, the only things that are contained in that bundle are annexures, but what we know before this commission is that Colonel Coetzee testified that following the transfer of dockets from the NPA during 2004, there were about 395 matters that she said not all of them had or were dockets. In other words, the 395 figure combined files and some dockets, meaning it could not have been 400 dockets. What is your comment on that?
It could be correct, Madam Chair. I have not had an opportunity since 2004 to check that register, and also I did not have an opportunity to read all these dockets. So I cannot say what the correct position is, and if she says it, I won't dispute it.
Okay. General Williams, who was the Deputy National Commissioner at the time responsible for crime detection and intelligence, also testified before the commission that he witnessed at least one box that contained material that related to publications by the ANC. No dockets in one of those boxes that he saw. What's your comment?
Madam Chair, what I also saw is that Colonel Brits was doing his own work. He was looking for amnesty applications to see if they related to the cases. He also had security branch intelligence reports where it would report that a sensitive informer has confirmed that there's been an ANC NEC meeting to carry out a wave of bombings to stop the 1988 election, or an informer says that this person was killed by the ANC, as he was suspected. So he had a wealth of material available to him.
Thank you, Advocate McAdam. So we can accept that the 400 number that you referred to may have been combination of dockets and some other issues that were not necessarily dockets.
Correct.
What Colonel Kotsia also informed the commission was that the documents included dockets where there were decisions or were decisions by the NPA not to prosecute, and some of them were investigations in progress. So you wouldn't disagree with it?
Madam Chair, as far as investigations in progress, when the task team was set up in 2006, the police were required to table a report before that task team of all cases that required investigation or prosecution, and Advocate Ackerman was the main representative in that committee, but I doubt whether any such cases were brought to the attention. I did see a report which Superintendent Bester compiled for Commissioner Jacobs, which only listed 8 cases, and in the main, they were simply seeking direction as to what to be done with the inquests, not to prosecute the suspects.
Now, in your understanding, those 400 dockets that were transferred, were they matters that were live?
Madam Chair, as I said, I did not read them, save as to check whether the entry in the register corresponded with the docket in question. I was looking to see if there was, in fact, this case against the President and these other prominent ANC leaders who had been refused amnesty by the TRC.
Colonel Kotsia informed the commission that the safekeeping of those dockets that were transferred from the NPA was for the purpose of mere storage, and they were regarded as closed.
Well, that is in direct conflict with what Mr. Ngluka told Commissioner Williams and Commissioner Price in the presence of the Director General Justice, Advocate Macaulay, that they were to go back to the police. They are police property, but they must be submitted if they need assistance and or a decision from the MPA. So it was not that the MPA said go and store them and just ignore them.
Okay. Now let's move to paragraph 28 of your affidavit. In paragraph 28, you inform the commission of Mr. Ackerman having addressed an internal memorandum to the NDPP requesting a meeting to discuss the TRC matters, more specifically the progress made by your office. You see that, you confirm. Paragraph 28.
I see that. I'm just trying to turn to AD6. I have it. I have AD6 in front of me.
And you can confirm in terms of AD6 that it was an internal memorandum by Advocate Ackerman.
That's correct.
You are aware of it?
Yes.
Okay. Now, if I may take you to same AD6, paragraph 86, commissioners would be page 299 of Galata Cross bundle. Now, if I may refer Advocate McAdam to paragraph 1.1 of 86, where it is titled TRC Matters 40 Minutes. You see that one?
That's correct.
Paragraph A says, progress made by Advocate McAdam's office. B, progress made into ANC-AW investigation supervised by Advocate Fick. Now,
correct.
B states that there was progress that was made into ANC-AW investigation supervised by Advocate Fick. What did that mean?
Well, that would, before this, we did not know anything about what Advocate Fick was doing on those matters. So we needed to see what the position is. Have they cases identified for prosecution? Are there cases that need to be guided for investigation? Or are there matters that can be closed off, amnesty granted, etc.? So that's all it meant.
In paragraph 6, Advocate Ackerman wrote that proposal for the further management of cases by my office and the DSO. You see that?
That's correct.
And management of those cases, TRC cases, would have entailed directing, meaning management and directing or direction given towards investigations in terms of the proclamation, correct?
Madam Chair, it refers to further management of the cases. So that is simply that the NPA would be discharging its normal mandate to give guidance and direction to investigations and make decisions whether or not to prosecute.
But now, Advocate McAdam, I think you referred us to the proclamation, and the proclamation spoke of management of investigations. Remember?
If I remember the manage and direct, that's what we say, not
Manage.
conduct an investigation. Manage an investigation that a police officer or a DSO member is.
Well, that's your interpretation. It's not specified
It's not
whether
my
that, what it
interpretation,
meant.
it's been dealt with in the legislation. And the legislation was all debated in Parliament, it had to go through the ministries, and if I remember correctly, there are even cases dealing with this.
But can you accept for the purpose of the proclamation, it is not specified what management of investigation meant?
You don't define things that are common knowledge. I mean, if you have an NPA act that refers to a prosecutor, you don't have to go and say, what is a prosecutor? It's a person who's studied an LLB, admitted as an advocate, has joined the NPA as the otherwise statutes, and that would be thousands of pages long.
But management, from your understanding, may be different from somebody else's management in terms of what is meant in the proclamation. Do we agree?
Madam Chair, we were at Edam, Mr. Nguka, Mr. McCarthy, Dr. Ramahiti, Advocate Ackerman, and myself, that it meant simply that we would manage investigations conducted by investigative agencies.
Okay, let's step off and proceed to paragraph 29 of your affidavit.
I've got it.
You stated in that paragraph that Advocate Ackerman or Mr. Ackerman submitted an internal memorandum to the NDPP, Mr. McCarthy and Dr. Ramaite, the Deputy Director of Public Prosecutions, under whose portfolio the PCLU fell. Now, you referred the Commission to AD7, which is that memorandum that you spoke to. AD7, that's now the memorandum of
I've got to just page to it. I would apologize, Madam Chair. I have
87?
severe arthritis. It takes me time to page to.
Yes, thanks, Mr. McAdams.
AD7 would be page 303 of the Galata Cross chairperson and Advocate McAdam.
Is, as I said, I'm trying to find it.
It's from page 301 of the bundle of the Galata Cross.
I've never been provided with a hard copy version of the Kalata bundles.
It is perhaps is there.
Chair,
It is in front of.
I apologize for interrupting. We do have a copy that we can provide to the witness.
Yes.
It is there. It is there.
So I apologize, Madam Chair. I didn't realize that these had been put in the corner here. I was working from the ones that I prepared with the State Attorney. Okay, now we need to go to AD7.
Ms. Ranto, how
Chair.
long are you going to be with the cross-examination of
Thank you. Got it.
Chair, not
Advocate McAdam?
Chair, it might be maybe appropriate time to take a break.
Yes,
We're anticipating that we won't be longer than an hour after adjournment.
an hour,
Yeah, it shouldn't be, at maximum,
Yes.
we're looking at an hour, please.
yes. I think this would be an appropriate time to take a tea adjournment until 25 to 12.
Chair, Ms. Reporter, with your permission, would like to be excused.
Mr.
Ms. Reporter.
Ms. Rukhoto. Yes, Ms. Rukhoto.
Thank you, Chair. We had placed an application to cross-examine, and I think it has come to the Chair's attention that we will no longer be proceeding with our cross-examination. However, I had come to place that specifically on record. However, something has come up. May I be excused, and I'll continue listening online.
Yes.
Thank you.
You will no longer be proceeding with the cross-examination of Advocate McAdam.
That, yes, that is
Yes.
true. That is
Yes.
true, Chair. We'll
You
just
are-
listen in case something is said, I don't know, through other cross-examination regarding Mr. Smelani, but from what he had said in his evidence in chief, we consulted and we decided that it was probably wiser not to cross-examine. It wouldn't be fruitful.
Yes. No, it's noted that you are withdrawing your cross-examination of Advocate McAdam.
As it pleases.
Yes. You may be excused.
Thank you, Chair.
Ms. Ranto?
Thank you, Chairperson. Before we adjourned, I'd referred Advocate McAdam to Annexure AD7 that appears on page 301 of the Galata Group cross bundle. Advocate McAdam is in front of you now.
I have it here.
Okay. And you can confirm that's a memorandum that you referred to in your affidavit.
It's the same document.
Now, if I may just request you to go to page 303 of 87, paragraph Roman figure 9, which is
Yes.
IX to 10.
I've got it.
Yes, where it reads, as a result of 3 audits in February 2003, cases were identified for investigation, registered, and the focus area of each investigation defined. So the identification was done by who? It would have been done by the PCLU.
No, it was done by myself. At that stage, I was the head of a DSO unit that had been mandated to investigate TRC cases.
And the registration,
The registration was as DSO cases, not as police cases.
okay, they were registered as DSO cases.
Investigations that the DSO investigative component will conduct, not the police.
And then Roman figure 10, the 41 investigations have been incorporated into a national project and budgeted. Cases are being registered on Eagle Eye.
That's the DSO processes,
So it would have been DSO.
DSO.
Okay, if I may refer you to paragraph B, capital letter B of the same memo.
Yes.
Cases dealt with by Advocate Fick. And then paragraph 1, SAPS appointed a retired SAPS members to investigate cases against the ANC and also the AWB for pre-election bombings.
That's correct.
So these are members that you said were reporting to their commanders at the SAPS.
For policing duties, but for prosecution activities, they would then be guided by Advocate Fick, who is the advocate in charge of those matters.
Advocate McAdam, earlier when I asked you as to where did they report to, your evidence was that they reported to their commanders with the SAPS.
But I also made it clear they were also working under the guidance of the prosecutors, in that case, Advocate Fick.
So we can accept for the purpose of this memo that those retired members of the SAPS were reporting to the NPA.
Only on matters where they needed assistance from the NPA. I can take it further and say when I did that spot check on the dockets, there were a number of cases that were written off as amnesty granted, and that was done by the police, not by the prosecutor. The police officer filed the amnesty judgment, and he himself made an entry in his register and signed off that entry.
We will argue in closing that your evidence is in total contrast from what was presented before the commission insofar as the reporting of these two retired members was concerned.
Madam Chair, I stand by my evidence, and I leave it to the commission, once it has heard all the evidence, seen all the documentation, to make a finding which version is correct or not.
Let's proceed to paragraph 2 of the same memo. It reads, a number of dockets were collected but investigations suspended due to an instruction from your office in January 1999. So this memo was addressed to the NDPP by Advocate Ackerman. We can accept that.
Yes,
And the memo refers to dockets being collected but investigations suspended as per instructions of who? Of-
Madam Chair, the collection of the dockets took place in 1996 on the instructions of Commissioner Fivers, and the decision to suspend the investigations by Mr. Nguka would be pending the outcome of the amnesty process, which had not been concluded at that stage.
But Mr. Nguka did have powers to suspend investigations.
Madam Chair, you can, as a prosecutor, say, don't proceed, you're wasting time, it's not good. But the police can still say, we disagree, we're going ahead, because it's our investigation, it's our evidence.
So you can say suspend, the police say don't, we don't suspend, then who's leading who?
Madam Chair, we make that decision based on prosecutorial processes and duties, responsibilities.
It's okay, let's just go to D1 of the same memo,
Sorry, which,
paragraph capital D,
Yes.
1. The title or the heading is Proposal for Further Management of Cases. You see that?
yes,
Now, paragraph 1, advocate fixed cases be transferred to my unit so that a full audit may be conducted in order to establish whether any of them have prosecution potential. All such cases will further be managed by myself. That was Advocate Ackerman.
that's correct.
So on your version, that refers to that management that you said it was simply to guide.
That's correct.
On
Because
20
if you
in the
look
same-
at the
Sorry, that's fine, I'm happy.
Yeah.
On the same paragraph, in the same, if you read the same paragraph, it says, on 22nd May 2003, I instructed that investigations be opened on matters identified by myself. Now, you have Advocate Ackerman that would instruct as and when that investigations be opened or reopened.
Madam Chair, I have no personal knowledge of what Advocate Ackerman wrote there. At that time, I was focusing exclusively on the DSO cases, so I don't know what informed that.
You refer to it in your affidavit, this memorandum. You refer to it in that paragraph that we dealt with. So I am aware that it's Advocate Ackerman, but you cannot differ that he gave instructions for investigations to be reopened. You cannot,
Madam,
you cannot
I
dispute
can't
that.
dispute that. All I can say is I don't know what informed that.
And then paragraph 3 of the same memo, it's the one crafted by Advocate Ackerman. That I assume personal responsibility for all cases currently being handled by McAdam, Fick and Pretorius. Since I am directly managing cases which are being investigated by the DSO, it is suggested that it be expedient and prudent that I be given appointment in terms of section 7, subsection 4A, 1, double A, and authorized to perform the powers of a director in terms of section 27, 28, and 29 of the NPA Act. So you wouldn't disagree with me that Advocate Ackerman felt that he wanted to assume powers to investigate upon being appointed, isn't it?
That is limited only to the DSO cases, because if he was given those powers under the DSO provisions, then he could be more directly involved in managing the investigations.
Correct. And remember your evidence to say that during your interaction with Mr. Nguka about the secondment, he indicated that the investigation responsibility belonged to the DSO. Remember that?
That's correct.
Yes. So in your interaction, even the memorandums, you wouldn't disagree with me that it was anticipated that the DSO would assist with investigation of the TRC cases, isn't it?
That's correct. The upshot of this meeting with Mr. Nguka is that the DSO continue with the cases I'd identified,
Yes.
and that Advocate Ackerman will now look at the cases that Advocate Fick had previously dealt with.
Yes. And in the proposed solutions by Advocate Ackerman, because that memorandum in terms of your affidavit was intended to set out the challenges that PCLU experienced with cases, the TRC cases, isn't it?
Beg your pardon. Madam Chair, the PCRU had not started to function at the time of this memo. The proclamation was issued in March 2003, but it was only in June that we started performing our PCRU duties.
Yes. Maybe just from what you said, in May already, on your own version, you were invited to join PCLU. That's in your statement.
That's correct.
Yes. So at the time when these memorandums were compiled, PCLU was in existence.
Madam Chair, I only assumed duties and transferred from the DSO in June 2003. Advocate Ackerman had been appointed in terms of the proclamation as a special director, but he had not started performing any of his powers under that proclamation.
I wouldn't go, but what we cannot deny from your factual account of what happened, you said, or you stated, that May 2003, you were invited to join the PCLU by Advocate Ackerman,
That's correct.
which means PCLU was in existence at that time, isn't it?
No, it doesn't. All that happened is he told me he had been appointed as a special director, and would I then join his staff. But the purpose of this meeting was to actually get us up and running. That's why I was asking for these powers, office accommodation, extra staff, a decision on a division of labor on these matters. He
So-
certainly was not performing his powers under that proclamation at that stage.
So you were invited to join a unit that was non-existent.
Madam Chair, at the level of the President of South Africa, this was declared in a proclamation in March. That proclamation was on the basis of a request by the National Director, concurred with the Minister, and it was seriously intended to get this unit up and as soon as possible.
But you did join that unit.
That's correct, in June.
That's fine. Let's go to paragraph 32 of your affidavit.
Can you give me the page, because this is a different...
Sorry, it would be page 240 of that bundle that is in front of the Galata Cross bundle. Page 240.
I've got it, thank you.
Thank you, Advocate McAdam. It is stated as follows: I could not make any progress on my cases because Mr. Ledwaba's approval of my project proposal as well as the 4 applications for authorization of investigation were still outstanding. This led to Mr. Ackerman and I meeting Mr. Ledwaba on the 15th July 2003 to discuss the matter. At the meeting, Mr. Ledwaba informed Ackerman and I that he had decided that SAPS must assume responsibility for all TRC cases previously under the DSO's purview. That's your statement,
That's
correct? And then we proceed to page 34 of your affidavit. That's on page 241 of the same bundle.
2-4, yes.
Yes, 241, paragraph 34. As a result of Mr. Lidwaba's decision, either in late July or early August 2003, Mr. Ackerman and I approached Commissioner De Beer, the divisional head of the Police Detective Service, to ask the South African Police Service to take over the TRC investigation from the DSO, including the Timor matter. That's your statement.
That's correct.
So what you're telling the commission is that the basis upon which you approached Commissioner De Beer was because of the refusal by Advocate Ledwaba.
That's correct.
If I may ask, from the beginning, when you were dealing with those investigations and the compilation of the memos that I took you through, was the South African Police Service, in particular, the National Commissioner or Commissioner De Beer himself, involved in your discussions or your planning regarding the investigations of the TRC cases?
No, ma'am.
They were not. So you cannot deny that you only approached Commissioner De Beer and probably remember that, by the way, the police also have responsibility to investigate because Advocate Ledwaba refused to come to your aid, isn't it?
That's correct. The police was the only other investigative agency that could perform investigative powers.
Thank you. Yes. And that was occasioned by Ledwaba's refusal.
That's correct.
Had Ledwaba agreed, you would not have approached the police, isn't it?
That's correct.
Thank you. Paragraph 35, Commissioner De Beer required that our request be put in writing, and we did this on 20 August 2003, meaning that request that you put your proposal in writing to the police by Commissioner De Beer, you didn't find it at odd, isn't it? Meaning you did not have a problem with it.
That's correct.
And then paragraph 36, on 26 December 2003, Commissioner De Beer wrote to Mr. Ackerman giving various reasons why the SAPS would not take over the investigations unless certain conditions were met, that either Mr. Ackerman or Mr. Nguga approached the president, at the time President Mbeki, and obtained an instruction from the president for the SAPS to take over the investigations. And then you referred to the letter of Commissioner De Beer, which is annexed to that document as AD 11. So if I may just refer you to Annexure AD 11. Sorry, Commissioners, it's in the Galata bundle. De Beer letter. AD 11.
Page 311.
311. Thank you, Chairperson. Yes.
It's
I'm
311.
indebted to the Chair. My apologies, Chair. It's page 311.
I've got it.
That is a letter that you referred to in your affidavit, correct?
That's correct.
And in terms of the letter, Commissioner De Beer, as you indicated, requested that Advocate or Mr. Nguga be approached or be requested to approach the president so that there could be clarity insofar as to whose responsibility it was to investigate TRC matters. Is that not so?
Yes.
Now, in your view, the approach by Commissioner De Beer in terms of that letter, would you say that it was unreasonable?
No, I wouldn't, Madam Chair, because he's now being asked to take over another unit's work when they've already been done by that unit.
So it was reasonable for him to seek clarity?
Yes, I understand his predicament entirely, because he said if the document is correct, there was this arrangement that the DSO would deal TRC cases and the police actually transferred police officers with TRC experience to to discharge that function. So if that's correct, now I can't say whether it's true or not because I wasn't, then it would be unfair to say, no, sorry, we've got these extra members from you, but now we want you to do their work.
Correct.
So I did not say this was wrong of Commissioner De Beer, which is why we went back to Mr. Dwaba and wrote to him asking to reconsider his decision and let us continue with the DSO working on the cases.
Thank you. So you wouldn't disagree that there was no lack of willingness to assist by Commissioner De Beer, right?
What I will say with Commissioner De Beer, because I had lots of dealings with him and on these other cases, and he was always very polite, always willing to accommodate, and in other cases where we, working with these police officers, delivered good results, he was always very appreciative.
Thank you. And you also not disagree that because of the fact that you didn't actually have a problem with his approach, that would not have been, or that would not have constituted political interference, meaning his letter.
No, Madam Chair, it was a operational decision by the most senior detective as to whether he should take over DSO cases or not. So it was driven by, if we look at his letter, issues of why should we take over some work when we've given them that capacity.
Thanks. So there was no political interference from your understanding of Commissioner De Beer's letter.
No.
And then paragraph 38 of your affidavit, that appears on page 242 of the bundle that's in front of you.
Right.
What you stated is as follows: in the meantime, due to the refusal of the SAPS to take over the cases from the DSO, no further investigations could be conducted into those matters which were, and in brackets you say, which were limited to TRC cases because the PCLU lacked its own investigative capacity. The PCLU relied on the DSO or the SAPS, and the PCLU's hands were tied, particularly given the refusal by the SAPS to assist. Now, paragraph 38 seems to suggest that there was refusal to assist by the SAPS, if I may ask.
Well, Commissioner De Beer had said no unless you go to the President. And this was a matter that Advocate Ackerman felt would not be the route to go. It doesn't mean that, it means that he had declined, forcing us to go back to the DSO.
But was that refusal, or it was an issue of clarify something, we are willing to help you once that has been sorted out?
Madam Chair, this was, I believe, he said, it's not the end, go and talk to the President. But what we said is, let's rather deal with Mr. Lavdwaba, get the DSO, because they'd already done quite a lot of work, they were experienced investigators.
Meaning, Commissioner De Beer did not prevent you from continuing with your work?
No, because that's why we went back to the DSO to say, please do it. And this is where there's quite a strongly worded email sent by Mr. Ackerman to Mr. Ladwaba, setting out all the steps we'd taken since July to persuade him to do the investigations. And Mr. Ackerman cited the extreme prejudice that was being suffered because of this non-investigation.
Now, going back to what you indicated earlier, that the dockets were always in the custody of the police. Remember the transfer of dockets, 400 dockets?
That's correct. Those were the dockets that were under the control of Colonel Brits and the Brigadier.
And now, DSO being in charge of investigations, did they also carry dockets?
Yes, Madam Chair. The members of the De Oliveira unit had transferred to the DSO, and they had taken the dockets with them.
So the NPA was in possession with,
The-
of some dockets?
Yes, these were the DSO investigators who had been tasked to take over those investigations, had uplifted those dockets.
Yes.
I cannot recall whether they were still in police hands and they were signed over to them, or whether when they came from police to DSO, they took the dockets with them.
So we can accept that it may well be that PCLU did not have dockets, but the NPA as an organization was in possession of some dockets.
Correct, Madam Chair. The NPA will always have dockets in its possession because of its duty to make decisions and other functions on dockets.
I'm talking dockets not for the purpose of taking decisions, but investigation of dockets.
No, no, Madam Chair, the DSO was an investigative agency, so the starting point is what do we have to launch the investigation? So if there was a police investigation, they will draw it because the police are not going to now investigate it, and that will then be re-registered, and then from then on they will be gathering all their own evidence.
And then, thank you for that, Advocate McAdam. If I may ask, the request for General De Beer to assist was limited to those cases that were identified as having potential or prosecution potential.
No, no, he was asked to take over the DSO cases. So if I remember, you see, the thing is, there is a letter that Advocate Ackerman wrote to Commissioner De Beer, which we can't find. I've looked for it, and that tells us what was intended to be taken over. But it was whether they're prosecution or whether it's matters that still needed investigation or not. But it was now, the DSO has washed its hands completely in the light of Advocate Ledwaba. So anything that needed an investigation powers would have to be dealt with by the police.
So, going back to what you stated or informed the Commission earlier, that investigations have always been responsibility of the police. That means, at the time when you requested Commissioner De Beer to assist, other investigations that the police were assist with at the time would have continued, isn't it?
That's correct. I mean, there were investigations on non-TRC matters where the police were investigating those matters as per their normal duties.
So if the Commission was to find that General De Beer's refusal to assist you resulted in some form of conduct, whether political interference or otherwise, which we do not accept, you would not agree that such finding would have to be limited to those dockets that were handled by DSO. In other words, the ones that you solicited his assistance with.
I don't know if I've grasped the question.
Okay.
All we wanted, take over the DSO work. So anything we say about this matter is limited to that.
Okay, thank you for that, please. Well, I will not pursue, I think, my next question because Advocate McAdam, you did say that investigations in relation to other matters continued as usual. And then we can then go to your communication with the DPCI. You'd recall in your statement, you informed the Commission about, I think your first interaction was with General Lala, where you requested to have a meeting with General Dramat, who was the first DPCI head at the time. That was during 2009. You remember that?
That's correct. There are annexures in my affidavit
Indeed.
dealing with my interaction between Commissioner Lala, General Dramat's office, and then finally General Labia.
Yes. And then your interaction with General Labia resulted in the appointment of investigators or some form of assistance from Senior Superintendent Bester at the time, correct?
Correct. What happened is we were working with the Crimes Against the State unit, which was now part of the DPCI. And then General Labia said they will now take over the TRC cases because they're already working with us on the other matters. And the CATS was a unit that fell under DPCI and no longer under the General Detectives headed by Commissioner Lala.
Yes. And then I just want to refer you to some letters that seem to have been born from, well, your paragraph 65 seems to have been informed by that
Paragraph
process. Perhaps if you can go to
65,
paragraph 65, page 249.
I've got it.
In March 2010, nevertheless, my apologies. It reads, in March 2010, I nevertheless tasked out the investigations to the DPCI so that when they were ready to investigate, they would already know what was required of them.
That's correct.
That's your statement. Now, if I may require, I may request you to go to the bundle, the police one, the initial one, the smaller one, where, no,
It's updated SAPS bundle.
yes, yes. Page 35 of that bundle. It's annexure VC3 commissioners to Colonel Kotsie's affidavit. Do you have it, Advocate Makado?
I do.
Okay. This is a letter from the NPA addressed to Senior Superintendent Louis Bester, dated 9 March 2010. You have it in front of you.
I do.
And you can confirm that it's one of those correspondence that you addressed to the-
To Superintendent Bester.
Indeed, yes. And that would have been VC3 up to, I think, is VC11, if I'm not mistaken.
Yes.
Yes. Now, if I may now refer you to annexure VC4.
VC4. I have it.
That would be page 38 of the bundle in front of you.
I have it on your page 38.
Yes, 38. VC4, you have it in front
Yes,
of
I do.
So that is also one of the memorandums that you addressed, or
Yes.
the letters. One of the letters addressed to the DPCI. Now, in terms of that memo or a letter, one of the matters that you referred to there was Reverend Chikane matter. Would you agree with it?
That's correct.
If I may refer you specifically to page 39 of the same letter, right at the bottom. Perhaps before you go, a second, second from
sorry,
bottom.
I'm missing a page. I jumped from page 38 to page 40.
39. Listen.
Thanks a lot. Yes, I have it now.
Yes, I want to read out to you where you started dealing with the matter of Reverend Chikane, okay?
Yes.
That appears on page 39. Third paragraph from bottom reads as follows. The investigation is further complicated due to the fact that Reverend Chikane subsequently was appointed as the Director General in the Office of the President, and in his capacity decided, well, I can't see, but documents relating to the case. It is to be expected that if Smith is prosecuted, that his lawyers will request access to all reports or all records in the President's office relating to the matter, which obviously affects national security. So I think Smith, you would have referred to Bassey Smith.
That's correct.
And that was one of the suspects in the Reverend Chikane matter, isn't it?
That's right.
And then the next paragraph, Reverend Chikane also complained about the manner in which the plea bargain was conducted and testified at the Genoala Commission. In addition, he recorded on national television with the original 5 accused, and also published an article dealing with how this case contributed to nation building. It is only to be expected that he would be extensively cross-examined on all these issues where Smith to be prosecuted. And then the last paragraph, in light of the above, before commencing on a lengthy and costly investigation, it is recommended that Reverend Chikane be approached at a senior level and requested to indicate whether he in fact desires any further investigation in connection with the matter.
That's correct.
And that was your recommendation, isn't it?
That's correct.
Now, evidence that was led before the commission by General Jacobs was that during the interdepartmental task team that you indicated in your affidavit that you only attended twice, the matter of Reverend Chikani arose. You cannot deny that it was discussed, isn't it?
I know it being tabled. I cannot recall whether it was at a meeting when I was present or not.
Yes, I can accept that. What played out during the ITT meeting regarding Reverend Chikani appeared to have been a view that was reported to have been the view expressed by the National Commissioner about the Reverend Chikani matter. You may not be aware of that.
Madam Chair, it's not something I had first-hand knowledge, but what I do recall is that Advocate Ackerman had put on record he is going to proceed with this prosecution, and that it was then put on record, I think, by Commissioner Jacobs, that the National Commissioner said Reverend Chikani does not want a prosecution, and that resulted in Advocate Ackerman and Advocate Marga then going to Reverend Chikani to see whether he wants a prosecution or not. And if I remember correctly, Advocate Ackerman advised that Reverend Chikani leaves this matter in the hands of the prosecution. That's my recollection. I could be mistaken because it's a long time ago and I wasn't dealing with this directly. It was Advocate Ackerman.
Yes, it does accord with the evidence that's before the commission. Thank you for that, Advocate Macadam. But then one of the things that was tabled before the ITT was that there was a recommendation by the SAPS that before prosecution in the Reverend Chikani matter would be proceeded with, there was a need to consult Reverend Chikani to ascertain as what his stance was in relation to the prosecution of his accused. What's your comment regarding that?
That is correct. It was requested because this is not the normal case. Reverend Chikani was the Director General in the Office of the President. He had reconciled publicly on television with Minister Flock by washing his feet as an apology. He had had a lot of engagements with both Van der Merwe. So and he's still alive, he didn't die. So if he says, look, I don't need a prosecution, I've reconciled with the people who are responsible, is it desirable that we go ahead against his will, perhaps undermine nation building? That was the view. And that's why you'll see my last portion of my letter, I recommend to Superintendent Bester that he should first confirm with Reverend Chikani whether he in fact desires it. Because to proceed with this matter would be a very costly. All the evidence relating to the poison was held by the FBI in America, and there were also a lot of other complicating factors.
So by having requested that Reverend Chigani's position be ascertained, that's now the SAPS, you would not interpret that as political interference?
Not at all. It's raising a legitimate concern.
And it accorded with your view as expressed in the letter?
That's correct. It would cause harm, in my view, if you forced a victim of a serious crime to go ahead with a prosecution that he did not desire. Because I dealt with cases where people had been tortured. I interviewed them personally. They said they don't want a prosecution. They've gone ahead with their lives. They don't want to stand in court, face their torturers, be cross-examined, and be re-traumatized.
Thank you. And then maybe if I may take you back to paragraph 56 of your affidavit, which is on page 246 of the same bundle, the Galata.
I'm just sorry, I've got so many bundles now.
I'm sorry about that.
No, it's not your fault. I'm just trying to find out which bundle. Is this again related to my affidavit?
That other one, the one that's got your affidavit, yes. So I'm referring it to your affidavit.
Let me just... Oh, that's my... Is it not this big, thick one here? Because I'm just thinking that probably my affidavit and that is all, this, yeah, but it's like pages 437 and that type of thing.
Oh, that must be the master bundle.
Everything's in here. Thank you very much. Madam Chair, would it cause any irregularity if perhaps my junior be permitted to sit with me for no purpose other than finding
To
the right
assist him,
pages? Particularly,
yes.
I've got arthritis.
Yes.
It's not to coach me how to
Yeah.
answer questions or anything.
Yes.
It might speed the process up, if
I
that's
think
permissible.
that's in order, Advocate McAdam.
And we have no objection to that, Chair. The next chair. Thanks. So, Ms. Michizana, if you may assist.
There we go.
Yeah. Let's start with paragraph 55, on page 245. Paragraph 55 of Advocate McAdam's.
I have it.
Yes. You stated that after taking over Mr. Ackerman's responsibility, I discovered that the TRC committee was not meeting, nor were any investigations being conducted. That's your statement.
That's correct.
Now, these investigations would be in relation to which cases?
Madam Chair, these were all cases that the task team had identified requiring investigation. What had happened is at the first meeting of the task team in October 2006, SAPS accepted responsibility. They would conduct all the investigations, appoint investigators to them.
In one of the ITT meetings, General Jacobs attested to the fact that he was assigned to audit cases that were handled by the police, and Advocate Ackerman was assigned to conduct audit of those that were in possession of the NPA. Are you aware of that?
Correct. The police were called upon to present their cases and Advocate Ackerman to present his matters.
So which means there were matters that were handled by the NPA, correct?
That's correct. These were the ones that we wanted the DSO to investigate, and they then declined. So it was those matters.
So there were dockets that were handled by the NPA in that regard.
Because they'd been uplifted from the police when the DSO was appointed to start investigating these matters.
But you wouldn't disagree that there were dockets or matters that were handled by the NPA and others by the SAPs, correct?
Madam Chair, these dockets were handled by the DSO, the investigative component of the MPA.
Hence I said NPA because they were under the umbrella of the NPA, correct?
That's right.
Yes. And then paragraph 56. On my return, I engaged with Police Commissioner Jacobs, who was a member of the TRC committee, also known as the task team, and Mr. P. Richer, a Deputy Director General in the NIA. You confirm that?
That's correct.
Now, you stated in that paragraph to say that both Commissioner Jacobs and Mr. Richer agreed with me that investigations should progress subject to approval by their principals and under the same auspices that the TRC committee had operated, correct?
That's correct.
Which means there was common understanding that investigations would progress.
Yes.
And there was no instruction that came from the late National Commissioner Silebi to say that investigations had to stop at whatever moment. Nothing.
Madam Chair, as I recall it, is that when Advocate Pakoli was suspended, Commissioner Williams, who was acting as the National Commissioner, wrote to Advocate Mshe and said that as a result of the suspension, the police were withdrawing from the task team.
No, I'm not talking about the withdrawal of the task team. What I want just to have a common understanding was that the NPA never received any instruction from the SAPS, either by Commissioner Slavey or Commissioner De Beer, to say that stop investigation of TRC cases, correct?
We're then going back to then 2003, and that is in fact true.
There was no instruction. There was
No.
there was no,
No,
instruction. Yes.
Commissioner De Beer made it clear if the President gave the order, they would do it.
Yes.
And there was no further, as far as I'm aware, involvement in any of the actions that flowed where Commissioner Salebi was involved.
And you were also not aware of any instruction issued by the SAPS to any of its members at whatever stage to say that there should be stoppage of investigation of TRC cases, correct?
That's correct.
Then we can proceed to paragraph 63 of your affidavit. That would be on page 247.
I have it.
You stated that Commissioner Lala informed me that he would facilitate a meeting with General Anwar Dramat to arrange for the DPCI to conduct the investigation. Then you attached that. Just to
Yes.
confirm, these were investigated related to the cases that you had identified
Yes.
to General Libya, correct?
Yes. This would be, the list that I presented would have been a consolidation of the reports that Commissioner Jacobs and Advocate Ackerman had did.
Yes.
It wouldn't just be limited to my original DSO cases.
Yes, but you would have identified that they had potential of successful prosecution,
Yes.
right? Yes. And then at some point, I think it's, let's just check, communication with General Lala, it was June 2003, where you requested some assistance.
Correct. Commissioner Lala had become the divisional head of the detective service, and he had the power to then not only agree to take over the investigations, but to assign investigators. And that was the purpose of me meeting with, on a regular basis with Commissioner Lala.
And also, he did not display any conduct of lacking willingness to assist,
No,
right?
Madam Chair, our final meeting is we'd agreed there were former policemen who had joined the DSO, but who are now coming back to the police because of the DSO being disbanded. And between Commissioner Lala and I, it was agreed that he would put those policemen who had TRC experience into a special task team working out of his office with his budget, and they would work with me on those cases exclusively. So that was a really good deal I got from him.
Yes, so there was willingness to assist.
No.
Nonetheless. And then during evidence in chief presented by Colonel Bester or Colonel Bester, who was then at the time you interacted with him as senior superintendent, and he stated or informed the commission that you and him enjoyed a good relationship and you worked in other matters harmoniously. Would you confirm that?
And also on these TRC cases, he attended the one meeting, the second meeting with General Labia when the three of us then discussed the dynamics of it. And I referred all these cases to him, which you have as annexures, and he straight away appointed investigators. And at that stage, I had to do all the TRC cases, not delegate them to other people. So I was then engaging directly with his investigators.
Yes. And he stated that, like yourself, he was engaged with other
Yes.
investigations, one of them being the one related to the nuclear weapons. You recall it?
I prosecuted the case myself.
Yes, and he says you worked closely with him in that investigation.
That's correct. In every single case, you work closely with the commander because the commander has to support the police investigations. We can say, do A, B, and C, but he has to then say vehicles, extra investigators, get a cyber expert, all these things. So you would always work very closely with your unit commander.
And then his evidence is that during your interaction, other than the March 2010 correspondence that we canvassed, you never raised any challenges that you had with investigation of TRC cases.
Madam Chair, I stand correction. I think that shortly after the cases were referred to Superintendent Bester, he retired. So if I'm mine, it was simply kick-starting, and the ayahs would come, and you can see from the letters there'd be a lot of work that had to be done before you build up cases of substance. So in that initial phase, I don't think there were problems. But what I will say is, and I'm not criticizing the police, when Brigadier Carver was appointed, there were issues of delays, inexperience, etc., which we had to address. And I mean, we have to accept that. South Africa has far too much crime for the prosecutors and police who must deal with it.
Now, Advocate Sean Abrams, during his testimony before the commission, dealt with ministerial memorandum dated 15 July 2015. Now, if I may refer you to an extract from, or SK3 to Advocate Abrams' affidavit, and that appears on page 206 of the Master Bundle, Commissioners, and I think it's page 111 of the Galata Cross, 111.
I think this is, sorry, we've got so many bundles. I think if it's that annexure, the ministerial member of Abrams, I have it in a bundle which the inquiry prepared for me in March, and I'm sure I'll find it. We just have to, yes, I've got SKA2,
Yes.
and the next document will be SKA3, I've got it.
Okay.
In our bundle, which the Commission compiled, it's page 206.
Just all. Yeah, the purpose of the memorandum is set out as it was aimed at providing Honorable Minister with a comprehensive report on the investigations and prosecutions of matters emanating from the TRC Commission. So that's the one that you have in front of you, right?
Yes.
Now, if I may refer you to page 124 of that memorandum, 124, paragraph 4.6.
4.6.
Yes. Dealing with attempted murder of Reverend Chigani.
Yes.
During the course of the plea and sentence agreement set out above, the accused in that matter implicated former security branch General Bassi Smith. The DPCI was requested to investigate his involvement, and now this is where we come in. The DPCI conducted a very weak and unsatisfactory investigation, claiming that Reverend Chikani could not be traced. Before the matter could be taken further, the crime prescribed, thereby preventing any further probe into the allegations involved, alleged involvement of General Smith. You see that paragraph?
Yes.
Now, during his testimony, Advocate Sean Abrams stated that that conclusion or those words would have been yours, or the expression or the view expressed in that paragraph, he would have been advised or informed by yourself.
Madam Chair, Mr. Abrams' position was in March 2013, when Advocate Ackerman retired, he was appointed as the acting special director. I was dealing with TRC cases on a monthly basis, reporting to him on the progress of the matters. In 2014, when I was taken to the to do the foreign briberies by Mr. Nkosana, Advocate Abrams was demoted and was instructed to take over the TRC cases with me. He was in that position required to work on the cases and on a monthly basis report to the acting head PCLU, Advocate Johnson, on progress, and then when he became national director, and that duty only stopped when he became national director. So I would say when Advocate Abrams writes to the minister, being fully aware of all these matters, he would know what the right facts are. Madam Chair, I know at my stage is that I'm unaware of the fact that Reverend Chikani could not be traced, but I am aware of the investigating officer telling me that Reverend Chikani said he was very busy with government business, would only be able to meet with him in 2 or 3 months' time. But then I checked myself that this crime had already prescribed in 2009. So we could not proceed with the investigation because we could not institute a prosecution. So I closed it on prescription, but I did highlight, and I'm not sure. You see, this is a long time ago. I can't say what the investigator did or did not do without me seeing the docket.
But can you remember expressing the view that DPCI conducted a very weak and unsatisfactory investigation?
Madam Chair, I'd have to check that docket and see what was done and not done before I could say that.
And
So
then,
you can't remember.
That's correct, Madam Chair.
and then Advocate Sean Abrams also informed the Commission that when he took over from you, there was no handover report
Madam Chair,
in
that was
relation to the TRC cases.
that's correct. It was totally unnecessary. When he took them over from me, I had been on a monthly basis reporting to him on what was being done on each and every case. His office was diagonally across from mine, the same distance from myself to Commissioner Johnson. If he needed anything on these matters, he simply had to walk into my office. In my view, a handover is called for when somebody new, who has no background knowledge, has to take over from scratch.
So in your view, there was no need to have a formalized kind of handover?
No, I mean, the man's on a monthly basis getting these reports. He's in my office. He can just simply come to me and say, I have a problem here. Can you help me out? Explain this. Because he had to report to EXCO on my progress every month.
Thank you. That brings us to an end, to an interaction with you, Advocate McAdam, and thank you very much for your
Certainly.
assistance.
Thank you.
Commissioner, that is the end of cross-examination on our part.
Thank you. Ms. Ranto, Mr. Vani. Oh, before Mr. Vani, the evidence leader.
Chair, with your direction, we thought you would follow Mr. Vani.
You'll follow Mr. Vani?
Yes.
Yes. Mr. Vani?
Chairperson, thank you. I'm just getting everything organized on my side. Chairperson, given that we have a great deal to cover, I just wanted to check whether Mr. Bana should be offered an opportunity to re-examine
Yes.
on
what
the evidence
Ms.
given
Rano
so
has
far, or would he prefer
cross-examined.
to wait until we've done?
Mr. Bana,
Chair, we
what
would-
would you prefer?
we would prefer to
wait
wait
until all the cross-examination has been conducted?
Indeed, thank you.
Yes. Mr. Vani?
Thank you, Chair. Mr. McAdam, firstly, thanks for making time to come back and assist the Truth and Reconciliation Commission. I think probably one of the two, and certainly we had quite a few interactions while you were at the PCLU in respect to certain cases. Now, we think you're in a very unique position to assist this inquiry, largely because you've been at the PCLU consistently since 2003. We recognize, of course, that there were periods of time when you were taken off the TRC cases to handle nuclear proliferation matters, corruption cases, and the like. Now, the main reason why we did apply to cross-examine you is that we have multiple documents in our possession, several of which were not put to you directly in your evidence in chief. And then subsequent to your evidence in chief, further documents dealing with transcripts and the like have come to our attention. And we're also duty-bound to put those to you. So there is quite a lot to deal with, because we're looking at several decades worth of work. And that's really why we suggested to the Commission that we set aside 2 days for your cross-examination. Of course, it's not just us. SAPs have now had their turn, and then after us, the evidence leaders will also wish to question you. We will try to truncate as much as we can, but there is a great deal of material. As you say, you're overwhelmed with files. I share that experience. I'm also struggling to keep track of all the paperwork. I want to give you a bit of a roadmap as to how we have structured the cross-examination, just to give you a sense of where we are going. We're going to start by taking you through your 2018 affidavit that you put up in the Rodriguez matter. We will then turn to the affidavit you put up in the Kadamang matter in 2015. Although we are aware that that actually wasn't filed, but it's nonetheless part of the record. We will then turn to your affidavit before the Commission of Inquiry. Then we will turn to the supplementary memos, or rather the supplementary bundle that we put up yesterday, which has just 3 documents in it. Then we will turn to the transcripts from the Craddock 4 inquest, dealing with various investigating officers. And then lastly, we'll deal with any outstanding matters that we have listed in our application to cross-examine you. As mentioned, we'll try to avoid repetition. And I am indebted to Ms. Runter for covering some of that ground. Where we can avoid the same ground, we will. But I suspect that some repetition will be unavoidable. I thought before we start that I should just get a few matters out of the way in relation to your various answers to Ms. Runter. I think if I don't deal with these now, I will probably forget about them. And also, I think your evidence is now fresh in your mind. So I think it's convenient that I pose certain questions arising from your responses to Ms. Runter. So with that behind us, let's start. This morning, you mentioned, by way of background, that the SAPs at the beginning were only focusing on the 400 ANC cases. And you then turned to explain about the cases against the former security forces in the apartheid regime. And you mentioned that the De Oliveira unit was dissolved. And you were about to elaborate on that when you were asked to stop and you were moved on to another question. So I want to give you an opportunity to complete what you were going to say in regard to what was meant to transpire in relation to the cases against the security forces once the De Oliveira unit had been dissolved.
Madam Chair, when Mr. Bulelani Nguka was appointed as the National Director in September, starting to lose my 1998, the following month, the Human Rights Violation Committee of the TRC released their first report, calling for prosecutions in cases where amnesty was refused or not applied for. So Mr. Nguka had then set up a special unit in his head office, headed by, at that stage, Justice Vincent Saldana, but at that stage an attorney, and Brink Ferreira, who at that stage was a deputy director in the Johannesburg office, and a deputy and other state advocates aside. But what they did not have is an investigative capacity. Why I know that is when I was dealing with the political violence cases, I would report to Mr. Nguka, I would chat to Messrs. Brink and Saldana, and they would draw this to my attention. Their also dilemma was amnesty process not concluded, so they didn't know, are the people going to receive amnesty? And obviously if they are, do we waste resources in a matter we can't prosecute? But what I had established is, unfortunately, the appointment of Mr. Nguka and the conclusion of phase 1 of the TRC process coincided with a massive spike in very serious organized crime that posed a real threat to society. I was working at the TRC from, I think, May 1996 until August 1998. I was pulled right out of that TRC to immediately go into Richmond, where despite 1,000 soldiers and police officers on duty 7 days a week, an unacceptable number of massacres were taking place. And I know in Gauteng there was a huge spike in car hijackings. Eastern Cape, with the merger of Ciskei, Transkei, Eastern Cape, there was major taxi wars because new routes had opened up. Cape Town had the urban terror campaign being waged by Pagat. And I know that the police officers were then drawn into all these current initiatives and ceased to function as a special unit focusing specifically on TRC cases relating to the security forces.
Thank you for that clarification. Now, I want to refer you to the document that's in the bundle at page 301, marked AD7. My learned friend from the police raised certain questions in relation to this document. And in particular, she referred you to the paragraph D3. And just to refresh our memory, this was an internal memo from Advocate Ackerman to the MDPP. It was dated 26 May 2003. And your testimony, as I understood it, is that these were proposals to get the PCLU up and running. And in that paragraph D3, which is on paginated page 304, Ackerman makes the proposal that he be given an appointment in terms of various sections of the NPA Act, including sections 27, 28, and 29, dealing with the authorization of investigations. Can I just check? As far as we're aware, he was never given such powers. Is that correct?
That is correct. Those are the powers that are unique to the DSO. So what he was trying to say, if I'm dealing with all the DSO investigations, can I also exercise certain of their powers? So it would fast track things because he could then himself authorize the investigation instead of having to go to Mr. Ledwaba. He could give instructions directly to investigators, etc. And that's why he was asking for those powers.
But unfortunately for him in the PCLU, those powers were never granted to him.
That's correct.
And then my last question arising from this morning, and this was after an exchange between yourself and Ms. Runtone in relation to the difficulties and debates around who should be investigating cases, with the DSO declining to take them on, and this is now following your request to De Beer. And then he suggests an approach to the president. Now, shortly after that, you mentioned in response to a question that the other matters continued as usual. So I'd like to know from you, when you mentioned that other matters continued as usual, which matters were these? Were these the other cases, such as nuclear-related offences?
That's correct. The primary mandate of the PCRU. Specifically at that time, we were doing a nuclear case, there were mercenary cases, and then also the illicit trafficking in military commodities, etc. So it was all the cases that fell under the CATS unit of the police.
Sorry, Chair.
And so you're saying...
Sorry, Chairperson, I don't mean to be rude to my colleague, but maybe before Mr. Vani carries on, he started off leading the witness to say, was it not one of nuclear matters and so on. So I just want to say, we caution my colleague not to lead the witness, to stick to the version that has to be put forward by the witness, Chair.
Yes, thank you.
Well, Chairperson, I'm not leading this witness, I'm cross-examining him. Under cross-examination, Chair, one's entitled to put versions to a witness.
Chair, the reason why that concerned us, because the issue of other matters continuing had nothing to do with nuclear investigations from the examination of the witness insofar as we are concerned. And that is why I was saying for Mr. Vani to come and say, wasn't that involving nuclear? He's trying to twist the story of what was never presented before the witness. And that's why we're saying, with the greatest respect, we really want to caution Mr. Vani not to put words into the witness' mouth.
Yes. Yes, Mr. Vani?
Well, Chairperson, sorry, there is an echo that I'm hearing from my side. I hope it's not apparent on that side. But Chairperson, this is what cross-examination is all about. One is entitled to put versions to witnesses. One's entitled to put up facts and ask whether they are correct or not. So I really don't understand the objection from my learned friend. Chairperson, may I proceed?
Yes, you may proceed.
Thank you, Chair. All right, so you've mentioned that other matters, let's call them non-TRC cases, matters continued as usual, and that these were being investigated by CAT section of SAPS. Is that correct?
That's correct, yes.
So at that time, were you and your colleagues perhaps scratching your heads as to why SAPS were happy to proceed with those cases, but not the TRC cases?
The reason that Commissioner De Beer advanced is that when the DSO was set up, the arrangement was that SAPS would transfer police officers with TRC experience to capacitate the DSO and for the DSO to deal those matters. Now, I was not involved at all in those negotiations. I can't say whether it's true or not, but that was the reason that he put in writing when he replied to us.
Thanks. We will return to your interactions with Assistant Commissioner De Beer in due course. So now I want you to turn to your affidavit that you put up in the Jean Rodriguez case. And Mr. McAdam and Commissioners, that's at page 137 of the Kalata Group cross-examination bundle.
I have it.
Thank you. Perhaps we can just kick off with you explaining why it is you came to make an affidavit in this particular matter, the Rodriguez application for a permanent stay of prosecution.
Do you want to know why I made this affidavit? Sorry, I didn't catch.
Yes. Why did you make this affidavit? Who asked you to make it?
Yes. Dr. Pretorius was acting as the head of the unit at that time. I was a deputy, mainly dealing with terrorism-related cases in the Joburg area. He handed me an application for a stay of prosecution filed on behalf of Mr. Rodriguez. He informed me that as the head of the unit, he would make the main affidavit, but he asked me to go through it, and if there were any aspects that I could assist relating to the averments made therein, that I should supply him with a confirmatory affidavit. So I read it, and yes, I believe there were important things which had to be placed before the court, resulting in the affidavit being drafted.
And in preparation of making out this affidavit, did you take time to research further and perhaps consult archives and documents at the NPA?
I couldn't obviously do a full search, but I tried to access as much as possible within the limited time, because I was informed that the NPA was running out of time on filing of papers. So what I attached to my affidavit is what I could find at that time.
Noted. Let's then turn to the next page, paragraph 8. And here you'll see that you indicate that the then NDPP, Mr. Nguka, back in October 1988, when the NPA Act came into force, he decided to set up a TRC unit in his office to deal with the TRC cases not already being dealt with by the DPPs. That's the last line on that page. Would I be right in saying that unit was the HRIU, the Human Rights Investigation Unit?
It was the one headed by Messrs. Saldana and Brink. I think its name changed a couple of times, but we're talking about the same unit.
Yes, yes, that's certainly the one we also had in mind. And then if we turn the page, you indicate that that unit was dissolved. My recollection is that that was approximately the year 2000. And you indicate because the amnesty process had not been concluded and that it lacked an investigative capacity. And then further down in paragraph 11, you point to the fact that the presidential proclamation establishing the PCLU was issued in March of 2003, and that Advocate Ackerman was appointed as special director of that unit that we now know as the PCLU, and that you were then transferred from a component of the Directorate of Special Operations, the DSO, to serve as one of his deputies. We could just pause there. Which component were you in at that time at the DSO?
I was head of the Special National Projects Unit. Our mandate was TRC cases against the security forces, as well as certain current organized crime projects.
Noted, thank you. And can you indicate to the Commission what resources you had at your disposal and if you viewed those resources as adequate?
I deal with this in one of my annexures to my March affidavit, where I point out we were extremely under-resourced. The investigators that were due to, you see, what happened is January 2001, I was supposed to do TRC cases for the DSO, but I was taken into witness protection. When I came back in 2002, nothing had transpired. The documents were all in a mess. It was very difficult to try and identify cases with prosecution potential. At a certain stage, Advocate Son, who was the head of the DSO at that time, instructed us not to proceed with the TRC cases, but then thereafter it was agreed that I would get investigators, a small team, starting in November, because they had to finalize their cases from the regional DSO officers. I got approval to employ two TRC researchers on a part-time basis. Advocate Pryor, who'd been one of the TRC's evidence leaders, also agreed to a short-term contract. But you'll see in the annexes that I attached to my March affidavit that all the capacity constraints, difficulties were all set out there.
So if you were to compare the resources that you had at your disposal in terms of personnel and investigators and prosecutors, it would compare poorly with, for example, what the late Attorney General, Jan de Oliveira, had when he was investigating similar cases.
Correct. I had one advocate to assist me. We had a very small team, very complex organized crime matters. With the TRC matters, we, in many cases, had to start from scratch. You'll see there's a memo that I wrote to Advocate McCarthy in February 2003, where I said, these are the cases we identified, this is what we need to do. And I concluded by saying, with our limited resources, we would have to prioritize. As far as the De Oliveira unit, Dr. De Oliveira, I'd worked personally with, is a very brilliant, hands-on Attorney General. There were 3 deputy directors dealing with these cases, Advocate Ackerman, Pretorius, De Jager, senior state advocates. There was a very good investigative unit headed by a brigadier with very senior policemen. When I was at the TRC, I worked closely with those investigators, and they were highly competent, skilled investigators.
Thank you, Mr. Ackerman. Chairperson, I see it's just gone 1 o'clock. would this be an appropriate time for the lunch adjournment?
Yes. Yes, I think this would be an appropriate time to adjourn for lunch until 2 o'clock. We are adjourned.
As the chair, please.
Are you well settled, Advocate Makalam?
Yes, Madam Chair.
Thank you. Mr. Vani?
Thank you, Chairperson. Advocate McAdam, I'm pleased to hear that you are well settled. Before lunch, we were busy on page 139 of the Kalata Group cross-examination bundle. I'd like you to turn to the very next page, 140, and I want to draw your attention to paragraph 19 of your affidavit. As a reminder, we're dealing with the...
Thank you. Yes, Ms. Moroka?
I was saying, Chair, our perennial complaint. If
You
Mr.
can't hear
Vani
Mr.
could
Vani.
speak louder.
Mr. Vani, there is a request that you must speak a little louder.
Chairperson, I will attempt to
Mr. Vani?
project my voice
Mr. Vani, yes.
louder.
Yes.
Is that better, Chairperson?
Yes.
Okay. And I was also asked to adjust the camera so that my head doesn't disappear behind various other items on the screen. So I'm hoping that I'm now audible and visible.
You are both audible and visible.
Wonderful. Thank you, Chairperson. Mr. McAdam, I want to draw your attention to a paragraph on the very next page, so that paragraph 140, and it's paragraph 19.
Correct.
It deals with the meeting that you and Advocate Ackerman had with Advocate Ledwaba at the DSO to arrange investigations of the TRC cases. I think we're all very familiar with the background, and you also testified about it this morning. I want to read to you the second line of this paragraph. The meeting was unpleasant, as Ledwaba made it clear in no uncertain terms that the DSO would not investigate any TRC matters, and that these should all be referred to SAPS. If you can you elaborate why you found that meeting to be particularly unpleasant?
Certainly, Madam Chair. While I was still at the DSO, I had submitted some applications in terms of Section 28(1)(a) of the MPA Act for him to authorize those investigations. I had also submitted a national project plan as well as a budget. When we had the meeting with Mr. Nguka, where he indicated that the DSO should continue with those investigations that I had identified, Advocate Ackerman immediately then started following up with Advocate Ledwaba. When is he going to sign those authorizations? And we were getting no response at all. I know Advocate Ackerman was constantly following it up, because now we wanted to move on those cases. We then called for a meeting with Advocate Ledwaba for a specific time. He made Advocate Ackerman and I stand outside his office for more than an hour before he would meet with us, and he was standing behind his table, and he said, "That's it. Take these matters to the police and end of story. Lease must now write up all the files to prepare them for handover." And all he did was say, okay, Advocate Tungwane, who'd done a lot of work on the Black Cat case, must finalize that. But it wasn't open to negotiation or anything. Now, my view is an instruction had been given for the national director. If he had any capacity constraints, all he had to do was call a meeting with everybody before Mr. Nguka and say, we can't work as you've ordered, let's see how we can do it. Not just shut everything down on the spur of the moment. That's why we regarded it as unpleasant.
Noted, thank you. Now, you make reference to the internal memo which was attached to your affidavit as RCM3. It's at page 155. If I can just ask you to turn to it.
I've got it in front of me.
And as you can see, this is an internal memo. It's it's directed to CRO Leask, and it's from Advocate MG Ledwaba. It's dated 15 July 2003. It's subject SNPU investigations. And under the heading TRC cases, Roman numeral 1, I'll read the first 2 lines. I have decided that SAPS must take over the investigations of all such cases currently handled by you. Your files should be closed off and all material given to the PCLU. So did this effectively mean that the Chief Investigating Officer, Leask, was from then on effectively barred from dealing with the TRC cases?
That is correct, Madam Chair. Everything was, all the files that he had were given to us, and they also made a storeroom available to us. And then, apart from doing me a favor on following up Mr. Kaji's information regarding the journalist, that was all he could actually do. I'd also emphasize, for Mr. Leask to do any investigation, he had to have that investigation authorized in terms of Section 28 by the investigating director, Advocate Ledwaba.
Yes, and we will return to that as well. Let's turn to the very next paragraph, because this then deals with your reaction to that meeting, which was to then approach Commissioner De Beer, Divisional Head of the Detective Services of SAPS, with the request that SAPS take over the investigations. Again, we're very familiar with this meeting, and you also testified on this this morning. But can I ask you to go to that letter, which you've annexed as RCM4?
Yes,
it's at page 157.
Yes, I have the letter before me.
All right. I just want to read you certain lines and then to ask you a few questions that arise. So that second paragraph, it says, as agreed at our meeting,
Sorry.
I have...
For the record, can you identify the document first and the date, Mr. Varney?
Yes, of course. My apologies. There was an oversight, Commissioner. So this document is a South African Police Services document. It's dated the 26th of September 2003. It's addressed to Advocate Ackerman, head of the PCLU. It's titled Investigation of TRC Cases. It refers to Advocate Ackerman's letter of the 20th of August 2003. And then I'm going to start reading from that second paragraph. As agreed at our meeting, I've discussed your request for the assistance of the SAPS to investigate cases emanating from the TRC processes with the National Commissioner. It is evident from your letter that the investigation and prosecution of these cases were referred to the NDPP by the President. Let's pause there. What referral is he talking about? We're not aware of a particular referral or proclamation.
The President lawfully cannot refer the investigation of cases to the National Director. Where the President came in is when he addressed Parliament, accepting the TRC report, indicating that although there were widespread speculation as to further amnesties, That was not going to be considered. The law must take its course. The cases must go through the normal process with the NPA working with its other partners. So all he did is say that the NPA must deal with them, with their partners, which would include the police. I've seen this speech of the president. I don't know if I have it now on the stand, but it's something that can be easily found.
Yes, no doubt it can. And my recollection is that the president did say that the NPA would handle these matters in the normal course. Although we would agree with you that that doesn't mean that one particular agency, investigative agency, is excluded and one has been selected. But let's move on to the next sentence. Understanding that this referral was politically inspired. What did you understand by the reference to the referral being politically inspired?
I don't agree with that. I mean, the president, all commissions have to submit their reports to the president. The president must respond to what the recommendations and findings of that commission are. And all he did was say that there are going to be no further amnesties. The law must take its course. I don't believe that is at all politically motivated. Even if he made no speech, the authorities would still have to deal with these TRC cases because they're crimes that need to be investigated and prosecuted if there's sufficient evidence.
And let's move to the next sentence. As you know, a large number of cases to be investigated are those of ex-policemen. It is therefore understandable that you first endeavour to have these cases investigated by the Directorate for Special Operations. Now, it's not clear to us whether that is an explanation as to why DSO rather than SAPS should investigate, since many of the suspects would be ex-policemen. Would that be a legitimate reason for SAPS not to take these cases?
No, Madam Chair. In the beginning, the De Oliveira unit, which investigated cases against the security branch of the police, members of the military, were all police officers. And that did not prevent them from investigating those cases because the suspects were also police officers or other government structures. The sole reason why the DSO was involved is that many of the De Oliveira police investigators had joined the DSO and they had already worked on these cases, had the historical knowledge. So it would make more sense that they continue with work with which they're familiar and have already started than go to people who have no background to these matters.
And in fact, as you pointed out, these investigators were all former SAPS officers in any event.
That's correct.
Or seconded by the police.
No, what happened is when how it started is the De Oliveira unit worked directly with Dr. De Oliveira. Now, what happened is investigating directorates were set up by Mr. Nguka in 1998 when he became the national director. Then the unit, the De Oliveira unit, stopped focusing on political cases and were drawn into the investigating, not all of them, but a number of them were drawn into the investigating directorates to deal with serious organized crime. When the DSO was established, those police officers could elect. They could return to the police if they so desired, or they could then transfer formally from the police to the national process and be NPA investigators. So that's how the whole process unfolded.
Yes, but the point being that the investigators who were with the DSO were themselves former police officers.
That's correct, yes. Andrew Leesk was an investigator in the Johannesburg branch of the De Oliveira unit. Niels de Lange was a key investigator in the Eastern Cape De Oliveira cases, where they investigated the then Port Elizabeth security branch on a number of cases. Slang Mangwale was also part of the De Oliveira unit and was involved in the investigation of the prosecution of Eugene Alexander de Kock.
They all had long histories in the erstwhile South African police prior to the De Oliveira unit.
That's correct.
So then we move on to what De Beer writes, presumably under the instruction of the then National Commissioner, which is that if the NPA gets a written instruction from the President, then they will investigate. But in the absence of such an instruction, they will not. Now, given that Commissioner De Beer was saying that the President's decision, in their view, was politically inspired, perhaps that explains why the SAPS required a further political decision if there's going to be a change in their view.
Well, Madam Chair, I can't understand why this could not have been resolved at an operational level between the National Director of Prosecutions, the National Commissioner of Police. And why should the President be involved in such a matter? I mean, one hears on the TV there's been a serious case and a decision has been taken now. The docket will be taken away from this police unit. It is given to a special unit, or for now with IDAC, the MPA is again has a investigative capacity, and you hear of cases going from the commercial branch of the police to IDAC and back and forth. So I personally don't understand why the President should be involved.
Yes, no, we certainly share that view. But as a matter of law, Mr. McAdam, one would have thought that we're a specialist agency. You mentioned some examples, like the DSO, won't investigate or is not in a position to investigate. And SAPS, under the law and under the Constitution, has no choice. They must investigate. They have a mandate that nobody else has to investigate serious crimes like murders and kidnappings. There should be no need for a presidential authority or decision on this matter.
Legally, in terms of Section 28, there is a provision which says that if the investigating director does not conduct the investigation submitted to him, he must refer it to, I think, the Director of Prosecutions where the crime's committed, and I think the National Commissioner. Now, that referral was never made by Advocate Ledwaba. He simply told Lees, you take them and dump them on the police. That's what you do.
Do you know perhaps why Advocate Ledwaba did not do this? Was it ever suggested to him?
Madam Chair, I have no idea what informed this. When the DSO was established in January 2000, I was required to transfer from KwaZulu-Natal, where I'd lived all my life, to do TRC cases. Fine, I was drawn into witness protection, but when I came back to the DSO, it was a given. I would be doing cases for the DSO, and that was confirmed by Mr. Nguka, the National Director, that the DSO should continue investigating the cases with which they had been seized from 2002.
Now, if we return to your affidavit, you point out in paragraph 21 that neither the NDPP nor Ackerman approached the president. Well, I assume Mr. Ackerman was not in a position, given his fairly low ranking, to approach the president.
That's correct.
But do you know why the NDPP, Mr. Nguka at that time, did not?
I don't know why he did not, but you will see in my annexures that after the meeting with Commissioner De Beer, we made several attempts to try and get Advocate Ledwaba to reconsider, culminating in Advocate Ackerman placing everything on record in his email of November 2003. He copied Mr. Nguka on that. Mr. Nguka then not only then instructed Advocate Ledwaba to investigate the cases that I'd originally referred to Advocate Ledwaba in May 2003, but additional cases that had come to our attention thereafter. So it was clear Mr. Nguka was adamant to the DSO would continue, and he was now forcing Mr. Ledwaba's hand. If it's a referral from the national director, Mr. Ledwaba has no discretion as to whether to investigate or not. His sole discretion, will it be a full investigation or a preparatory examination? My own view is we would have preferred to keep the cases with the DSO because of the experience of those former police officers, and they'd already done work on the cases we want to pursue. Going to SAPS, we go to the Crimes Against the State Unit, no historical knowledge, overwhelmed with all these mercenary nuclear cases, and the Boramach case was running, so a lot of their members had been drawn into that matter and were not available to attend to any other cases. So both Advocate Ackerman and I were of the view we wanted the DSO to continue.
Yes, that certainly made sense in the circumstances. Well, just so you're aware, Mr. McAdam, Advocate Nguka did testify before these proceedings, and he was asked the question why he did not approach the president. His answer was it would have been nonsensical for him to have done so, given that the Constitution and the law already empowered him to refer cases to either the DSO or SAPS. But let's move on. You've already quickly made reference to the fact that you made attempts to persuade Ledwaba to reconsider his decision not to investigate. It's also set out in paragraph 22. You make reference to the letter Ackerman wrote, in which he set out the consequences of these cases not being investigated. Time doesn't permit us to go into it. You state in paragraph 23 that the DSO, however, did not appoint investigators as requested. Consequently, none of the TRC matters requiring investigation could be taken further. I want to draw your attention to the fact that eventually later in that year, the NDPP did act in terms of Section 28(1)(b) of the NPA Act. And here I'm referring to an internal memo which can be found at page 316, the cross-examination bundle. And I'll just wait for you to get there.
Sorry, can you give me the page reference again?
Sure, 316.
Yes, I have it before me.
So this is an internal memo from the head of operations, at least from the NDPP to the head of operations DSO. It's dated 8 December 2003. It's titled Investigation of TRC Cases by the DSO.
Apologize, we
And
have
they're
on
the
our page 361 is the list of priority crimes, which was drawn up in 2019, so
It's 316,
Three- one.
Advocate
I
McAdam.
apologize, Madam Chair.
316.
yes, here it is. I
Thank-
apologize.
Thanks, Chairperson. No problem. We're all drowning in paper here, Mr. McAdam. So just to repeat, this is an internal memo. It's from the NDPP. Mr. Nguka at that time, to the head of operations, DSO, dated 8 December 2003. It's titled Investigation of TRC Cases by the DSO. And the NDPP writes, I've decided in terms of Section 28(1)B of the NPA Act that the following 3 cases, actually turns out to be 4, arising from the TRC be investigated by the DSO. And he lists them, PEPCO 3, Brian Ngulunga, Motherwell 4, and then the attempted murder of Reverend Frank Chikani. And then just to complete the story, if I can also ask you to turn to page 318, 318.
I have it.
And so this is a similar memo. It's from the NDPP to Advocate Ledwaba, Head of Operations. It's dated 26 February 2004. It's titled Referral TRC Cases to the DSO in terms of Section 28(1)B of the NPA Act. And if you look at the referral itself, these deal with APLA attacks. And if you look at the last line, it deals with the APLA attacks on the St. James Church and Heidelberg Cavern. So between December 2003 and February 2004, the NDPP refers these 6 matters to the DSO for investigation. My first question, Mr. McAdam, and this is from the perspective of the families, is why were so few cases referred to the DSO?
Madam Chair, if regard is had to the report that I wrote to Advocate McCarthy in February 2003, I think it's AD1, I listed the cases, but you can see extensive investigations would be needed. We'd be starting from scratch. And I indicated to Advocate McCarthy is the extent to which I could deal with them would be dependent on my resources, and we'd have to prioritize. So firstly, it is an issue of resources, because when I transferred to the PCLU, it was only Dr. Pretorius, full-time engaged with mercenary activities, not able to engage in TRC, and Advocate Ackerman and myself. So Advocate Ackerman had 400 ANC dockets. I had all the cases that I had identified. Secondly, I had to comply with Section 28, and that I had to persuade the investigating director there were reasonable grounds for those investigations, because I anticipated that the authorization would itself be attacked by the accused, and the investigation could be declared unlawful if there was non-compliance. This was stated in the Hyundai case, I think, of 2000. And therefore, I had to be very thorough in my applications. I attached the evidence that I relied on. There was a comprehensive report where I married the evidence to the DSO mandate, crimes committed in organized fashion. There was an affidavit from Mr. Leask confirming he had established all the role players that would be needed were in fact available, and we'd even drafted an investigation plan setting out step by step. So obviously, we could not take on more than we could do, and these were key cases that we had identified. The Ngalunga and Motherwell case go together. I'd identified that as the strongest case. It would have prosecuted General Nick van Rensburg. In each case, in a senior capacity in police, he ordered the killing of 5 policemen to prevent them from revealing their knowledge of murders committed by the security branch. So I put a lot of effort into that. Also with PEPCO 3, there had been an investigation by the Data Unit, amnesty hearings. And, that was also a case that we considered with pursuing. But they would take up a lot of work. In the Motherwell Ngalunga matter, in the prosecutions, 2 key witnesses had been found to be unsatisfactory, resulting in Motherwell of 2 of the 5 accused being acquitted, and in Ngalunga of the de Kock being acquitted on the murder charge and only on a conspiracy. In Motherwell, there had been a conviction with 3 accused. The Attorney General who conducted the prosecution had retired, so I had to take over the appeal before the SCA. There was also an amnesty application where General van Rensburg had been refused amnesty, but on review before the High Court, it had been directed that a new amnesty hearing be convened because the original committee failed to have all the evidence before it. Having taken over the criminal appeal, I had all the evidence, so I had to assist the Department of Justice in placing all the relevant evidence before that. So those were the reasons that we had to confine ourselves to what we could actually manage and deliver on.
Thanks for that very detailed and I think very helpful explanation, which does put us in the picture. So essentially saying the primary reason that you were forced to match your available resources with the limited capacity that you had at your disposal, so you weren't able to take on more.
That's correct.
And also thank you for giving us some information in relation to those cases, because we've also looked at these 4 matters. Well, I see you saying Ngalunga and Motherwell are connected. So these 3 or 4 matters, as well as the other 2 Appler matters, the St. James Church and Heidelberg Tavern matters, in which a large number of people were murdered. And we've struggled to ascertain what actually happened in these cases. So you've given us some information on Motherwell 4 and Ngalunga, and that the connection was a potential case against General Nick van Rensburg. As you point out, these cases actually took place. They were prosecuted and trials heard in the 1990s, but that there was the potential for a prosecution against Nick van Rensburg. Can I ask what ultimately happened? Because as far as we're aware, van Rensburg was never prosecuted.
That is correct. The referrals made by Mr. Nuka were at the end of February 2004. Now, shortly thereafter, I was drawn to deal with a nuclear case and no longer involved in TRC matters. So I have no knowledge of what was done by Mr. Ledwaba after the referral of these matters. My involvement with the TRC matters commenced again in June 2008, where Advocate Ackerman indicated that I must take over all his responsibilities in respect of TRC matters. If we look at the Brian Ngalunga, nothing was done because I would have known that personally because I was assisting the Justice Department with the new amnesty hearing, and I was reading the whole record of the trial because I had to defend the appeal against conviction in the SCA. And certainly nothing was done. And General van Rensburg died at the end of 2004, which has a major impact. Van Rensburg was not only a general, he recruited Dirk Coetzee into Vlakplaas. When the Eastern Cape became the flashpoint of resistance, he personally murdered, by putting his service revolver against the heads of Mtunkulu and Topsy Madaka, killing them, having their bodies burnt down to skeleton, the skeletons broken up into bits of bone, thrown in a sewer. He got amnesty for that case. He did not apply for amnesty for the PEPCO 3, but members of his unit did do so. He applied for amnesty for Craddock 4, but was refused amnesty. He was refused amnesty for the Motherwell case. He never applied for amnesty for Brian Ngalunga. When the PCRU started off, we had the background of acquittals in the Magnus Milan, the Votabasson and the Bishu massacre cases, and there was public concern as to whether the MPA was capable of prosecuting. So this would have been a key case to demonstrate efficiency. What had happened is, when we were doing that assessment in 2002, we reached out to a number of people who were involved in these cases, offering them the status of witnesses, and very little, or very few, if any, took advantage. Now, we believed a significant case like this would make those people who had sat out reconsider. General van Rensburg was old. Perhaps if he was convicted to get a lesser sentence, he might start bringing in the other police generals. So that's why we said this was a very significant case. We put all our efforts into it, and it came to naught. If Advocate Ledwaba had signed the authorizations when they were submitted to him, we could have got the matter into court. Even if he died before we got a verdict, it would nevertheless send out a message that the state can come up with credible charges and evidence. The PEPCO 3 matter.
Just before you move to PEPCO 3, are you aware whether the DSO, in relation to Motherwell and Ngalunga, whether an investigating officer was actually appointed?
Not
and if
at
so,
all.
who?
Not at all, and I can confirm that any investigating officer would have had to liaise with me in retrieving the evidence that was put before the High Court when 3 people were convicted, and he would also have had to be involved in the amnesty hearing, because witnesses for the prosecution would now be testifying wanting amnesty. And there was no such investigator, no approach to me, give documents, share them, give guidance, because I put a lot of work, so I knew a lot about those 2 cases.
Thank you. Sorry, before I interrupted, you were going to talk about PEPCO 3. Please proceed.
Correct, Madam Chair. This was a matter that Advocate Ackerman decided to enroll in towards the end of 2004, and in that matter, his decision was based on an investigation that had been conducted by the De Oliveira unit in 1996, and himself traveling to Limpopo, consulting with Rolf Venter, who'd been refused amnesty, and then deciding to use Rolf Venter as a state witness. Venter and Advocate Ackerman had to themselves compile the statement, which was commissioned at a local police station and not by an investigating officer. When I took over from Advocate Ackerman in June 2008, all the 2 main perpetrators, Gideon Nevitt, John Martin van Sale, were dead, and we could go no. And also, I identified key investigations had never been conducted. And you'll see AD 19 is my email to Advocate Ackerman asking him, while I'm overseas on official business, to supervise the work of the 2 state advocates. And there I set out all the issues that need to be addressed or so. The Commission has on its website a letter which Advocate Bokau, one of the prosecutors, had compiled listing all the investigations that needed to be done.
Thank you. And the same question, at this time, December 2003 or shortly thereafter, did the DSO appoint an investigating officer in PEPCO 3, and if so, who?
Not at all.
And the last matter we're more familiar with, that's the attempted murder of Reverend Frank Chikani. We know from the evidence of Advocate Ackerman that this had been previously investigated as part of the Basson case. And we're also very familiar that a plea and sentence agreement was eventually struck in 2007. But just to ask the same question, were you aware whether an investigator was appointed in that matter, and if so, who?
I don't, but what I do know is that the decision to prosecute the Chikani matter was because Anton Ackerman told me he didn't need an investigating officer. He could simply lead the evidence that had already been led in the prosecution of Voter Basson, and he could arrange for the accused just to report to court. You wouldn't have to arrest them, take them into custody, and that was his decision to then proceed with the matter because of lack of investigative capacity.
Thank you. To return briefly to the PEPCO 3 matter, you might be aware that that matter remains unresolved even today, and the NPA and the Minister of Justice have reopened that inquest, which is due to take place actually later this year in October. The individuals that you've mentioned, Rudolf Fenter and the other suspects, have all passed on. In fact, there's only one suspect remaining, former Flop Class member Choma Masela. Would you agree, Advocate Ackerman, that in relation to the PEPCO 3 case in particular, given that all the suspects have died without facing justice, that the PEPCO 3 families have been failed by the post-apartheid state?
Certainly, Madam Chair, if these matters had been taken forward at that time, the suspects were available, there were witnesses in both the Motherwell, Ungalunga and PEPCO 3. Certain of the people that had physically taken part in the kidnapping or killings had agreed to testify and had also been granted amnesty, so they confirmed that these are credible witnesses.
Then let's turn to. So I'm hearing an echo. Thanks. I think it's been resolved.
One very short point to this, if it's permitted,
Sure.
Madam Chair.
Yes,
it's important
you may proceed, Advocate McAdam.
Why, Madam Chair, when we started off, we assessed PEPCO 3, Motherwell 4, and Craddock 4, because they were all committed by essentially the same group of perpetrators. Now, on Motherwell and PEPCO 3, we had cooperating witnesses who would testify against the persons who'd given them the orders. On Craddock 4, none of the people that carried out the killings were prepared to testify against their superiors. So our belief was, if we were effective on Motherwell and PEPCO 3, that would bring the Craddock 4 alive. People would come forward and start talking.
Thanks for that useful background. So if I can just quickly ask you the very same questions on the applications, and this is at 318. This is the referral to the DSO, and perhaps we can handle them together to save time. Are you aware whether investigators were appointed in the St. James Church and Heidelberg Tavern massacre cases, and if so, who?
I would rather leave this to Advocate Ackerman to deal with, because in this period when it was referred to the DSO, that was when I was not dealing with the matters. But what I do know about these matters is that I referred them to the police, and I accompanied the police to Cape Town. We consulted with the former investigators and potential witness. So my knowledge of this matter is when it was gone to the police and it was being investigated.
But as far as you know, the DSO did not investigate those two cases?
That's correct, because I know this was one of the cases I referred to Superintendent Bester in March 2003, and I remember at that stage the challenge was that the dockets and the court proceedings had gone missing, and I know I went down with a Captain Nell from the police to Cape Town trying to find the material.
So there is a document which we'll come to later, which I believe is from 2019 or 2020, in which both these matters are mentioned, with the concern expressed that they have not been investigated. We will find that document, and later in my cross-examination, I'll bring it to your attention. But to save time, let's keep moving. And I should add, and perhaps secure your answer. Would you also agree that the victims in the St. James Church and Heidelberg Tavern massacres, and indeed other matters that were not investigated over these last years, have also been failed by the post-apartheid state?
I would not say it's the failing of the apartheid state.
Sorry, post-apartheid state.
Certainly, Madam Chair.
Post-apartheid. Post-apartheid state.
Thank you, Commissioner, for that clarification. Madam Chair, I have, I think, illustrated all the difficulties in investigations. The primary problem is when eventually you start, it's too late. Evidence is lost, you can't find dockets, witnesses are all there. Because we have a referral in 2010 by the police. That's the first time we start looking at these matters. 2019, I take over as the head PCLU, so I do all these efforts to dramatically increase the cases from 30 in the beginning to 112, ending up 114. But capacity of number of investigators, quality of investigations played a major part. If they had been investigated 2003 by experienced policemen, a lot of these problems wouldn't have surfaced, and also effective prosecutions in those cases would encourage people to come forward. So it would have opened up a lot of cases. You would have had people pleading guilty, offering to be, and that never happened. For whatever reason, I don't know.
Thank you for that important context. And indeed, this is the very meat of this particular Commission of Inquiry, is to get to the bottom of that. And we will be exploring that with you. Can I ask you to, if you're on page 141, this is your 2018 affidavit, and at paragraph 24, you indicate that you were then assigned during 2004 a case dealing with international nuclear weapons syndicate, and that required your full attention until late 2007.
Yes, that's correct.
But as you say in paragraph 25, notwithstanding that, Ackerman regularly discussed the TRC cases with you, And you point out a few of the things that he informed you of, including the fact that he intended prosecuting 3 former security branch members for the poisoning of Reverend Frank Chikani. That's at paragraph 26. Now, we're very familiar with what happened in that case. And if you turn the page, you indicate that Ackerman informed you that the acting national NDPP had put the prosecutions on hold pending the formulation of special TRC guidelines, and that there was now a moratorium on the investigation and prosecution of TRC cases pending the adoption of those guidelines. Did he also mention to you that acting NDPP Ramaita had been called by the then Minister of Justice Mabandla, directing him to place those cases on hold?
Madam Chair, I cannot recall that, but what I do recall is that Advocate Ackerman was furious that he'd been stopped from enrolling the matter, because that was done the night before the accused were there. He told me that there was an instruction from Dr. Ramahiti, and shortly after that, he again told me that Dr. Ramahiti is now instructed that a moratorium be placed on all investigations but pending guidelines. But I cannot recall if he told me whether somebody gave that instruction to Dr. Ramahiti, and if so, who that was. There was no documentation documenting any of this. It was just conveyed verbally by Dr. Ramahiti to Anton Ackerman. I never saw any official correspondence.
But in subsequent years, do I assume correctly that you did become aware that Dr. Ramahiti had been spoken to by Minister Mabandla in respect of this moratorium?
Madam Chair, I remember my original attorney giving me a copy of Dr. Ramahiti's affidavit, which was filed at this commission. And also, I'm worried about if I say things that are not correct, but I think in that memo he did in fact confirm both instructions were from the Minister of Justice.
Yes, we can confirm that does appear in his statement. Now, isn't this an example of brazen political intervention in the TRC cases?
Madam Chair, I don't want to use the word political interference, because what does it mean? Is it intervention by a political party? Is it then by a member of the executive, and then is it not executive interference and not political? But clearly, my view is that you cannot have a Minister of Justice, if in fact she did that, saying you can't enroll a case in court, because that interferes with the independence of the MPA. Similarly, when it comes to guidelines, the Constitution and the MPA Act clearly state that the guidelines are formulated by the National Director, but they must have concurrence by the Minister. So the prime mover of the guidelines is the MPA and not the Minister. The Minister is there simply to say yay or nay. And also, if you look at the MPA Act, it defines how the Minister exercises her final oversight over the MPA. It's calling on the National Director to give reports to her on specific matters that are of concern, and there's also the reporting to the Parliamentary Portfolio Committee.
Yes, perhaps executive intervention is a more accurate description than political intervention. And since you've raised guidelines, let's move to paragraph 28, which deals, in fact, with the guidelines dealing with the TRC cases. And you state that you and Ackerman were both of the view that they were unconstitutional. Can you elaborate on why you thought the guidelines were unconstitutional?
Madam Chair, they made provision that if a person comes forward, meets the same criteria as is set by the Amnesty Committee, then the National Director can decline to prosecute. Now, whether the person meets the requirements of the Amnesty Committee is absolutely irrelevant as to how the MPA deals with persons who have committed crimes. There is firstly the general policy that anybody implicated in a crime can make representations as to why they should not be prosecuted. More importantly, you've got Section 204 of the Criminal Procedure Act, which makes provision that if a person who's committed a crime testifies against the other and gives satisfactory evidence, then that person is indemnified from prosecution by the court trying the matter. Now, that's what was there. And in my view, that was all we needed to deal with this. In my view, this meeting that is absolutely irrelevant. It actually narrows the scope for you to use Section 204 witnesses. In the TRC, many of the cases where amnesty was denied is that the persons lacked a political motive. So if a person comes to me and said, I acted purely out of criminal motives, but I can testify against the rest, there's no reason why we do not take him, and if he's a good witness, he or she a good witness, they get indemnity. So why do we need to bring in meeting the requirements of the Amnesty Committee? They're irrelevant. That's my answer. And
Thank
what
you.
I'm saying is that this putting that provision in triggers a lot of controversy because rightly or wrongly, the public think this is a second TRC, and we have the Azapo Concord judgment before the TRC justifying the amnesty process solely on the basis it's a once-off transition from oppression to democracy. So vis-a-vis that judgment, no more amnesties.
Well, and apart from the TRC amnesty criteria, which you correctly point out became part of the new Part C criteria in the guidelines or the amendments, whatever you want to call them, it went even further. There were additional criteria upon which the NPA could decline to prosecute. For example, if somebody could show that they have been subjected to indoctrination. So it went even further than the amnesty criteria.
That's correct, because if you look at those cases as well, there was the CCB who used a Cape Town gangster to facilitate those crimes. Now, if that gangster comes forward and says, I can implicate these very powerful people who committed these crimes, why can't he be used as a witness?
Yes. So
But
just
there's
to
also one
conclude,
case I remember where the main perpetrators all got amnesty because it was politically motivated, but now amnesty was refused to a foot soldier who said, I only joined in after they'd already shot the person and he was lying on the ground for fear that they would kill me. They turned around with their guns pointing directly at me. I was afraid. Then the TRC said, well, you only get amnesty for political crimes and not fearing for your life, so we refuse it to you. Now, that would be the best person to use as a witness if those main perpetrators had not been granted amnesty.
Sorry, can I
thank you for those examples.
Can I just ask you something about the head of the CCB, Vester? Remind me, did he appear before the TRC, or was he ever investigated?
Commissioner, Vester was not the head of the CCB. He was the head of the Johannesburg cell, which was made up of former police officers to do dirty tricks in South Africa, where you need police officers to know what clues you not need to leave on the sign. if I remember, there was a General Webb who was overall in charge of the CCB. Now, the scary thing is that investigations only revealed that Joburg cell. There were these other 39 cells that operated externally, of which nothing is known about what they did. And there was no accountability at all. I worked on the Anton Lebowski's case where I had no doubt he was murdered as a result of a CC conspiracy, but it was impossible to get any CCB member to give us a coherent account so you could then base a prosecution on that person's evidence.
Yes, and if I repeat the same question about General Webb, did he testify? Was he ever investigated?
Madam Chair, I don't know if the TRC but I can confirm he never came forward as an amnesty. Nothing was put on the table by the CCB. A key case for the CCB to come clean on and apply for amnesty would have been the murder of Anton Lebowski, the SWAPO leader. All I know about the CCB is there were some members who came forward and in a prosecution had Ferdy Barnard convicted. He was at that stage a foot soldier. I worked on the early learning centre case where a bomb was planted outside the centre but nobody was killed or injured. And my difficulty is the only witnesses there were people who were 204 witnesses for the De Oliveira unit, and the others had all been granted indemnity under the Indemnity Act. So I couldn't prosecute at all out of that, and the people who got indemnity weren't going to ever cooperate with the state.
Yes, thank you. Thank you, Mr. Vani.
Thank you, Commissioner. Mr. McCallum, just to wrap up the section on the guidelines, at paragraph 29, you point out that they were ultimately declared unconstitutional for the reasons you've applied. But in summing up the guidelines, would you agree that that they were primarily aimed at providing further avenues to permit apartheid-era perpetrators to escape justice? Here I'm referring to all those criteria, and that it ultimately was an unwarranted interference with the NPA's prosecutorial discretion?
Certainly, Madam Chair, because as I said, 204 doesn't need to be linked to political motives. Why do you need guidelines for these matters? After the cutoff date for the TRC crimes was 11 May, let me just remember, 1994, and in certain parts of the country, that political violence continued, specifically in KwaZulu-Natal, where I was directly involved. We addressed the KwaZulu-Natal political violence, which was extremely serious post-TRC, with no special guidelines at all, simply applying Section 204 of the Criminal Procedure Act. Almost without exception, those cases were only solved by accomplices turning against the people who ordered them.
Thank you. Let's then move to what you have to say about the interdepartmental task team. You don't give dates in paragraph 30, but my recollection, and I stand to be corrected, that this task team, known as the ITT, started meeting towards the end of 2006, I believe around October 2006. Is that your recollection as well?
As I recall, there was a minute, I think I might have filed it as one of my annexures in my March affidavit, documenting the first meeting, which was in October, and it was a high-level meeting with Advocate Pakoli and certain of the DGs.
Yes.
I can assist the Commission by checking if I do, in fact, have it as my annexure.
It's okay. I don't think there's any dispute that we're talking about, late 2006. So if I look at your paragraph 30, you indicate that you were informed by Ackerman that Pakuli had set up this interdepartmental task team to advise him on making decisions in the TRC matters. Ackerman and Ramaite were the NPA reps on the task team. On one or two occasions, you say, I stood in for Ackerman in meetings of the task team when he was not available. And then your last line, I'm going to read into the record. I noticed that the task team was predominantly comprised of members of the intelligence community who were more intent on cross-examining me as to why matters should be investigated rather than addressing the issue of all the outstanding cases. So let's first deal with the allegation you make that the task team was predominantly comprised of members of the intelligence community. So we all know that NEO was represented on that task team. They had two representatives. So could you not be criticized for saying it was dominated by the intelligence community, given that they had two members?
Madam Chair, the guidelines made provision for only one member from police, NIA and justice. And when I said it was dominated, on the meetings I attended, there would be at least 3 intelligence officials. And when I brought certain cases to their attention, I got the impression they were cross-examining me. So it was in that context, and not saying that the whole committee was intelligence related, because there were the 3 NPA people. But what I picked up as well, there was no representation from Commissioner De Beer or a senior detective in the task team.
Can I ask a question, Mr.
Yes, my recollection is that...
Mr. Vani?
Can I have a minute?
Of course, Commissioner.
In paragraph 30 of your affidavit, where you're looking at
Yes,
now,
Commissioner.
Advocate McAdam, do you think your use of the word predominantly comprised of members is correct?
No, Madam Chair, I should have been more careful
Okay.
and said it was limited to only the questioning of cases being presented.
Okay, thank you. Thank you, Mr. Varney.
Thank you, Commissioner. My recollection, Advocate McAdam, in relation to the police, I think you are correct that detective service was not there, but there was a legal services officer by the name of Philip Jacobs or Jacobs. Is that your recollection?
That is correct, Madam Chair.
And are you saying that the detective division should have been there?
Correct, Madam Chair. The whole purpose of setting up this task team was to get these investigations going, because the guidelines had been approved by Parliament already in December 2005. The PCLU had no investigative power, so that's why not only were the police made a representative, but also the DSO, because in the absence of Advocate Pakuli withdrawing Advocate Nguka's referrals in 2004, the DSO was still actually bound to investigate those cases themselves. May I just also add with Commissioner Jacobs, because it illustrates my point about not having a detective in this matter. I tabled the Highgate Hotel case because of sensational media reports about the matter. The TRC found it was an APLA case. Nobody, however, was prosecuted or applied for amnesty. And because of the high public interest in the matter, I felt that this should be looked at. Now, I have the minutes of a task team meeting of the 29th of January 2007, which notes that Commissioner Jacobs informed the meeting that he has gone through
So,
the
sorry to interrupt. Can you just give myself and the commissioners the page number so we can also find it?
Madam Chair, I don't know if it was part of my March affidavit, but in preparation for my cross-examination, I found the document. I don't know if it's permissible to raise it if it was not part of my affidavit.
I'm happy, with the indulgence of the chairperson, I'm happy for you to raise it because I do believe that these minutes are part of one of the bundles before the commission today. So please go ahead.
Thank you, Madam Chair. I only need to read out one short paragraph.
Just remind us again, what is the date of that
The
minute?
meeting is the 29th of January 2007. The paragraph that the paragraphs aren't numbered, but the paragraph says the following. Commissioner Jacobs informed the meeting that he has gone through the docket on the Highgate Hotel attack and is of the view that no further investigations is necessary. I would like to refer the Commission to the police bundle where, I must just find it here, in March 2010, I have to direct extensive investigations into that matter. As a starting point, the two whistleblowers who came forward and said this was not an Apple attack had not even been asked to submit statements. It documents a score of statements not being commissioned. It documents not following up of a photo parade, but most significantly, the investigating officer of that case only asked ballistics to compare the spent cartridge cases on the scene, AK-47 cartridge cases, with a very, very small number of cases. Although, at that time, the use of AK-47s in political cases throughout the country was highly prevalent. When I then asked the head of the ballistic unit in Pretoria to draw all the cases of AK-47 rounds going back to 1993 and compare it, he then said he'd appoint a senior person to do the exercise, but then he phoned and said they'd established that those spent cartridge cases found on the scene had now been stolen. So that was the end of probably your most objective and direct link to this case, because those ballistics would come up. It's linked to this case, that case. You can start focusing on who the suspects are, which is the political organization. We couldn't do that. We lost that vital evidence.
Chair, if it's useful, we've got copies if you want to take this in as an annexure.
Yes, I think it will be useful to distribute the copies.
I'm
Were
not
included
sure
in the
where you
distribution,
reached
Chair.
it. So annexure, we'll hand it up.
And are the parties included in the distribution?
I'm not
What
sure.
exhibit number should we allocate to
I
this
have-
number?
I have no idea. I haven't been following the exhibits. Perhaps somebody else can.
Ms. Moroka, are you able to assist?
Not at this time, Chair. I can't recall what was the last one.
Yes. You will consider,
Yes,
Ms.
I think the evidence leaders may be able to.
Well, Chair, we don't have
Chair.
a collection of the last one, but it should do no harm to use the abbreviated.
Council, sorry, switch on your second microphone. Yes, thank you.
I was saying, Chair, that we do not necessarily have the last exhibit number, but it would do no harm to use the initials of the witness and a capital A to identify the document.
Chair,
Yes.
Sorry to interrupt. I don't know if it will be of any assistance, but the minutes of 29 January 2027 is PCJ 11 at 1753 of the master bundle.
Yes, but we want to allocate an exhibit number for purposes of this cross-examination.
That's Chair,
So
please.
it will be exhibit MA. CMA. CMA.
CM-A, noted, Chair.
Yes. Yes, Mr. Vani?
I'm indebted to the chairperson for that intervention.
Madam Chair, may I just close this issue by referring to VC3, page 35 of the police bundle. That is the letter that I wrote to Superintendent Vesta on the 9th of March 2010, identifying a range of investigations that were required.
Mr. McAdam, thanks for drawing our attention to that letter. I'm going to propose that we move on, but we will mark VC 10, and we will, in all likelihood, return to it once we've studied it in more detail. Before we move off this topic, there was one other SAPS member on the ITT. His name is Josiah Lekala. Do you recall him, and do you know which department he was from?
I may be incorrect. He may have been crime intelligence. I doubt he was a detective, because if he was, he could have been taking the lead when all these issues relating to investigations have to be dealt with. Whereas in the same minute that we received now, this one of January 2007, Commissioner Jacobs is the person who says now he's having to contact provincial commanders to get investigators, not this person.
Noted. Yes, well, we will certainly endeavour to check on that, and perhaps our colleagues in the police can advise us in due course. But given your view that the detective service was not represented on the ITT, and given that there is a view that the ITT was meant to assist facilitating investigations, what did this say to you?
Well, Madam Chair, as I said, I only attended a couple of these meetings, but in June 2008, Advocate Ackerman instructed me to take over. I then established that no active investigations were being conducted on any of the matters that had been identified as requiring investigation. That resulted in me having to undertake this long process of firstly engaging with Commissioner Jacobs and Pete Richer from the NRA at getting investigations up and running, subject to they wanted approval from their principals, that's the Director Generals, and the task team being convened. I attached in my March affidavit the memo which Advocate Mshere wrote to the Minister, documenting all his efforts to try and get the task team established, but nothing happened, except that because I had worked very closely with Commissioner Lala in the political violence, and he was now the head, I would approach him directly and let's get these things going. And you'll see he was at the very point where he was going to give us a good investigative capacity. That is when the decision was taken that the specialized units of the police would now all be transferred to the DPCI. That would leave him with only detectives investigating the less serious crimes, which was a result of me then making all these attempts to get General Dramut to buy in and agree to do those cases. You can see that Commissioner Lala was actually helping me by setting up these meetings. It's all documented in my emails, and that led to then me meeting with Commissioner Labia. At that stage, he was the deputy to General Dramut, and that's when we had a buy-in. And then these investigations then only commenced in 2010.
Thanks, Advocate McAdam. We are jumping ahead a bit, but I understand your need to disclose important information. But if we can return to the unfolding story at paragraph 31, you indicate that Advocate Pakuli was suspended, and we know that took place during 2007. It was not long after the plea and sentence agreement. And then you point out that he was ultimately fired despite the commission finding he was competent to be the NDPP. Then you point out in paragraph 32 that during the course of 2009, the acting NDPP, Mshere, summoned you to his office and showed you a letter written by SAPS indicating that it was withdrawing from the task team. And then you write, and I quote, this is at the bottom of page 142, this would mean that, again, TRC matters would not be investigated because at that stage a decision had already been taken to disband the DSO. So I need to ask, why would investigations of the TRC cases be dependent on the task team? Why couldn't those investigations, and these are very serious cases which would fall within the mandate of the SAPS, murders, kidnappings, and the like, why could they not have proceeded with or without the task team?
Madam Chair, if the task team had properly functioned, it would have been a significant fast-tracking of investigations, because there you have one detective, you refer all your investigation needs to him, you have intelligence people who can do the intelligence gathering, justice is there. Without them, you would have to be running around trying to set things up, etc. I came into the PCRU from the political violence in Richmond, and we were able to, in a period of 2 years, blitz that violence because it worked on a task team approach. We had dedicated prosecutors, dedicated investigators, a special intelligence component, and all the other backup we needed. We even had a special high-risk arrest team. So if you needed to arrest people, they could immediately effect those arrests. Otherwise, you'd have to make a request, and they would say, sorry, we're attending to a cash and transit robbery. We can only help you in, say, the end of the week. So when you bring all these people together, we put our heads together, we work full-time on these matters, you see significant results. Because if you look at the cases, they were spanning all over the country. Now, to try and arrange with individual provincial commissioners, etc., would be difficult. Justice played a key role, firstly. If people decided to now challenge the refusal amnesty, Justice had to reconvene, deal with the review process, and Justice was the custodian of all the TRC records. So you have one person straight away get all the stuff you need. So that's why I believe that if it had functioned as task teams do function and are effective, it would have been a different story.
Yes, although my question is a slightly different one. The question really is as follows. The normal detective service, and even yourselves at IDEC, you did not have a task team comprising Department of Justice, intelligence agency, and other officials from the executive. And nonetheless, you got the job done. So I'm still querying why the TRC cases, murders and kidnappings, could not have been investigated in the normal course in the absence of this task team.
Madam Chair, that would have meant that the MPA would have to start itself, building bridges across, provinces and that type of thing. What I'm saying is having a dedicated lot is, a major, plus factor. It's just how it operated. Because, when I retired, I was given a 3-year contract to work with the investigating directorate. And there were arrangements in place with the SARS, the Financial Intelligence Agency, dedicated commercial crime, branch people, financial, and that also helped us enormously, that we would not have to be running around from pillar to post to try and get help. So my view is if it had functioned properly, it would have helped.
Yes, I don't dispute that if things had worked optimally and everybody shared the same ambition and energy, it certainly would have helped. But we know that the last meeting of the ITT was in January of 2007, and either in this statement or your subsequent statement, you conceded it never met again.
That's correct.
So the question is, well, how come SAPS simply didn't pick up these cases and investigate? Because we're not talking about 2009. It says in early 2009 you were summoned, and the ITT met last in January of 2007. So we're talking about 2 years previously.
Madam Chair, I can't give that answer. All I can say is that when I was told to take over and I realized nothing had been done, that is when I took these drastic steps lobbying commissioners of police to get the process going, doing the memo for advocate and share, alerting the minister. But the people who were responsible for that lack of activity, they should come and explain that and not me.
And who are they?
Well, if you look at the first meeting, there are all the principals listed. And those are the people who were there to make sure the process functioned properly.
Yes, I do recall that you make reference to the fact that principals have to sign off, and we will come to that. In the next sentence, you say, MSHA instructed me to negotiate with SAPS to agree to investigate the matters, which he said I should take over from Ackerman. And I suppose the obvious question again is, why did you have to negotiate with SAPS when it's already clear that under the Constitution and under law, they are required to investigate? It shouldn't require negotiation.
Madam Chair, I was an office bearer of the TRC, spent my life doing violent crime. I've seen the enormous suffering that victims of... So my conscience and my oath of office required me to do what I can to get things going, which eventually happened. But I believe if it had not been for my efforts, there would not have been that buy-in to investigate in 2010. If you look, I attach my emails, all my desperate efforts with Commissioner Lala, my failed attempts to meet General Dramat. I would like this inquiry to specifically look at my annexure AD22F. This was the Lebowski case where we only had jurisdiction on a conspiracy which would prescribe after 20 years, which would have been September 2009. How I'm begging and pleading at least that we have one investigator to attend to that matter. What had happened is Mrs. Lebowski had briefed an advocate whose instructions were if the MPA did not prosecute, he would then conduct a private prosecution. So I said if the crime prescribes in September, my decision must be made in August, so if it's not to prosecute, he has sufficient time to meet all the requirements to have a private prosecution. An investigating officer was only appointed on the 27th of July 2009. AD 22F is where I say that there is a Colonel Hoop, who is a former de Oliveira investigator, who's now being transferred to crime intelligence, but can't he use to quickly investigate that case? Even if necessary, I'll pay for all his expenses out of my own budget. That's how desperate I was to get this done. And what I, as a feel very bad, is why do I have to do this? If 10 people are gunned down in the street outside, are the police going to say that, no, we'll do nothing at all, the MPA must come cap in hand begging us and pleading us, and then we'll actually investigate? Because at this time, the Scorpions were out. So the ping pong matches at Scorpion is out. It's a sole police responsibility. If one looks at that first meeting in October 2000, the police accepted they will do all the investigations, even though the DSO was still in existence and a member of the task team.
Thanks, Mr. McAdam. And we certainly empathise with the frustrations that you have expressed.
My frustrations
and
are nothing compared to the suffering that these poor victims go through. We were often in the embarrassing situation, you give undertakings, yes, these matters will be investigated, and you can't deliver on it because nobody's investigated. It's terrible. The PEPCO 3, myself, Advocate and Chair, the National Director, the DPP, had to spend a whole day with the family of the PEPCO 3 explaining why we can't proceed with that case. And it's those people suffering. You know, as a lawyer, I have to have a thick skin. But that's the real heart, is those victims. And I'd like to say, look at all these letters where there's ping-ponging and nothing being done. Where is the plight of the victims reflected in any of those communications?
Yes, I think we're in agreement with you, Advocate McAdam. So, given that context that you have just painted, would you agree that you should not have had to negotiate with the SAPS? It should have happened in the normal course.
That's correct. I mean, if you look at that task team, it's convened at a very high level. So the people there should have got all of this done, and I would just be informed, these are your contact people, let's get going, sir.
Well, except in the situation that we're at the moment, recall that we're now at 2009, and here you have the acting NDPP asking you to begin negotiations, and it's either in this statement or the next, where I think he does ask you, and perhaps my team will help me find the correct reference, to see if the task team can't be resuscitated 2 years down the road. And I believe the answer was that SAPS would not investigate unless their principals gave them the go-ahead. Is that correct?
That's correct. I think it's actually documented in our reports, and I think there's a memo that Advocate Chair wrote to the Minister explaining the issue.
Yes, when we find that reference, we will put it up. Let's move on, please. So at paragraph 33, you mentioned that Ackerman has already disposed of a number of matters, and he gave you a list of a smaller number of cases. You estimate that to be around 10, but that the Timol case was not one of them.
That's correct.
You then attach, sorry, there is a disturbing echo on my side, but I'll continue. You then attach a string of emails between yourself and various role players. And you make reference of Raymond Lalla, then Divisional Head of Detective Services, You indicate that he eventually advises the National Commissioner has directed that the cases be investigated by the DPCI. I just want to go to one of those communications at page 162 of the same bundle.
I have it before me.
And I just want to quote you a couple of lines from the email from Helena Swart. Correct me if I'm wrong, that was your secretary?
That's correct.
But the email is from you.
Yes.
It was sent on Monday, 18 May 2009 to Willie Hofmeyer. And Mshe, Ramaita, and Ackerman were copied. Subject investigators for TRC cases. You're right, dear Willie. And I should add, just by way of context, am I right in saying that the reason why you were writing to Hofmeyer was that there was an expectation that he was going to be appointed the new head of the DPCI? Is that right?
Madam Chair, I had heard that that was correct. I have no direct knowledge, but the main reason I wrote to him, he was responsible for the transfer of the DSO to SAPS, because this is May 2009, the DSO dissolved in July 2009. So that was my primary responsibility. Any movement of people out of the DSO to SAPS, I would have to work through him. But I know Mr. Hofmeyer very well, we're personal friends, and he would definitely have wanted these matters done.
So I'm going to read, I think, the first 3 lines. I met this morning with Commissioner Lala concerning the appointment of SAPS investigator to investigate the TRC cases, where victims have asked the NPA to look at prosecutions. We have been taking quite a beating due to the fact that nothing has been done on these matters for a number of years. And in fact, in certain cases, the victims are threatening us with mandamus applications. Were you surprised by that time that such mandamus applications had not already been brought?
No, Madam Chair, there was huge, well, the first thing is there's suffering of victims that are being denied justice, but prominent human rights organizations were also severely criticizing the NPA for non-activity, and there again, I feel very strongly about this. All these attacks were on the NPA, but almost without exception, the reasons were delay rested with the investigations. We had no investigators. Madam Chair, these are not shoplifting cases. You can't say if 4 people are blown up in a car bomb to prevent them from revealing the involvement of the security branch in the Craddock 4 and other serious crimes, that you can just leave it gathering dust. Fair enough, if it was a shoplifting of a Sigma chips packet, that would be a different story.
So let's move on. So in paragraph 35, you indicate that you ultimately met with Assistant Commissioner Lebeya on 26 November 2009, where you discussed the issue of conducting these investigations. And then he positively responded by way of a letter on 18 January 2010. And then you make reference to the fact that Senior Superintendent Bester was appointed to oversee the investigations of the 10 cases that you had identified. If I can just pause there, and again, from the perspective of the families, they would want to know why only 10 cases, why not more?
Again, what had happened is capacity constraints and to try and at least get these things going. Because they'd be going to the CATS component that we'd worked with since a very small team, and most of the experienced investigators were full-time in the Boeremach, so it'd be going to people who didn't have the historical background and were also inexperienced. So we were trying to, get a small number of cases, start showing impact, because that will immediately make things easier. People who are sitting these cases out will now decide I should actually be a state witness, and it might also motivate to increase extra capacity within both NPA and SAPS.
Thank you. Noted. Now, you make reference to a letter that you wrote to Assistant Commissioner Lebea on the 18th of January 2010, which is at RCM 7. If we can go to RCM 7, it's at page 167.
Yes, I have it before me.
So I just want to focus on the bottom paragraph dealing with Senior Superintendent Bester. And let me read it in the record so we're all on the same page. Senior Superintendent Bester of your office attended our meeting and informed you that he was in possession of a number of further dockets, which he felt also required investigation. On 6 December 2009, I had a meeting with Senior Superintendent Bester and established that those dockets were related to cases against the liberation movements, in respect of which a decision was taken in 2004 by the then National Director not to prosecute. Perhaps let's pause there. And you finish off by saying there was no basis to reopen those cases. Now, given that Bester knew that a decision had already been taken not to pursue with these cases back in 2004, do you know why he was still pushing these cases in 2010, 2009 and 2010?
But he knew about it because when Mr. Nguka confirmed my decision, I wrote a letter which was given to Colonel Brits, and thereafter Superintendent Bester and Colonel Brits came and saw me, and they said that there is a solid case against the President contained in one of the dockets and wanting me to prosecute the President. Now, what I said is I didn't say, get out of my office, I've made my decision, don't waste. I said, no, give me that docket. I'll consider it and evaluate it and make a proper decision and take it up further with Advocate Ackerman, and Advocate Ackerman would take it up with National Director.
And there's at least another reference which we will come to in relation to Bester wishing to pursue cases against the ANC. Did you get the impression that he had something of a preoccupation in pushing cases against the former liberation movements?
The impression I gained is that he had been influenced by Colonel Brits. Because, I mean, in all my engagements with Colonel Brits, both Advocate Ackerman and I, he was always adamant about this case against the President, and it was clear to us he was also in communication with Johan van der Merwe, the former Commissioner of Police. Now, Superintendent Bester comes in out of the cold to now suddenly take over. What I suspect is he was influenced by Colonel Brits.
Yes, we'll come to Colonel Brits because you do make reference to him later in your statement. In paragraph 37, you point out that Advocate Menzies Simelane was appointed as the NDPP, and then he moved you into serious corruption investigations in the Northern Cape. That, of course, meant you were taken off the TRC cases.
No.
Was that an unfortunate decision that hindered the pursuit of the TRC cases, in your view?
Madam Chair, we were in a situation of limited resources. When Advocate Simelane was appointed, we just had this buy-in that the police would start investigating, and Dr. Romahiti and I gave him a briefing about the TRC cases, and he then instructed me to draft a ministerial memo, which was to the effect that the police must, without further delay, proceed and finalize these investigations, and secondly, that because all the cases were investigation related, the police should take the responsibility for investigations. Now, as you'll see, I tasked these investigations out in 2010, so it was at the early stage. So, although doing the serious corruption in the Northern Cape slowed me down. If I was working full-time, obviously I could move, but it didn't stop them. The investigators had investigations to continue. If there was something urgent, they would still phone me while I was in Kimberley, and we'd make a plan. So it wasn't certainly aimed at blocking the TRC cases, but I'd like to tell the Commission what the condition was. Advocate Ackerman had withdrawn from the TRC cases already in 2008. He wasn't available, therefore, to deal with them. We had myself doing the TRC cases. Dr. Pretorius and Advocate Abrams were involved in long security-related matters that were keeping them out of the office and out of the province. The only remaining member was Advocate Bokar, and what had happened is she had been diagnosed as having cancer of the bone that connects her hip to her knee. She had to have a bone transplant, and she had to lie flat on her back for 6 months, because if the graft had not taken, they would have amputated her leg from the groin. So it was capacity constraints and not any attempt by Advocate Similani to stop the cases. He could have told me, don't proceed with them. But we did deal with them. We did report on the matters.
Thank you. Okay, so that then does answer my next question as to who was running the cases in your absence while you were in the Northern Cape. And essentially you're saying the only remaining member was Suzanne Bokar, but she herself was incapacitated. Just a follow-up question. You mentioned that Ackerman had already withdrawn from the TRC cases as far back as 2008. According to Advocate Ackerman, sometime after the plea and sentence agreement in the Chikani matter in 2007, Advocate Mshere relieved him of his day-to-day duties in the TRC cases around that time. Is that what you're referring to when you mention withdrawn?
No, Madam Chair, I refer to an annexure. I think it's AD 18. It's an email that Advocate Ackerman sent to Dr. Ramahiti, recording a meeting that he had had with Dr. Ramahiti and I, and he said that it's now agreed that I will take over his position in the task team and will manage the portfolio, and it's all set out in detail there. So, as far as I'm aware, he was not removed because of the Chikani case in 2007. He elected in June 2008 voluntarily to withdraw from the cases. I don't know if afterwards there was a meeting with him and Advocate Mshere, but all I know is after the email, Advocate Mshere called me to his office, showed me the letter from the police saying they're no longer going to take part in the past team and appealing to me to get things going and investigations on track.
Right. Well, we won't do it now in the interest of time, but we will put to you Ackerman's evidence, and in fact Mshere's evidence as well, who confirms that he did withdraw or remove Advocate Ackerman from day-to-day duties in the TRC cases, largely because of complaints leveled against him in the Chikani matter, but in the interest of time, we are going to move on. You then point out at paragraph 38 that Mr. Nasana was appointed as the NDPP, and he also removed you from the TRC cases, or rather, he asked you to act as a dedicated prosecutor for foreign bribery cases. And that advocate, Sean Abrams, who was then a senior state advocate, was appointed to take the TRC matters over from you. And this was the case until June of 2015, when Abrams was appointed NDPP, as you allude to in paragraph 39. So while you were doing these foreign bribery cases, and prior to Abrams being appointed NDPP in June 2015, are you aware of any progress that was made in the TRC cases?
Madam Chair, I'm unaware, but for example, on the Craddock 4 matter, I sent him an email saying that that matter has been outstanding since September 2012, pending Advocate Jeeba's decision. And as I said, he was across the road from me, he could always come to me. But what would happen is that when he became the NDPP, Advocate Bukhar was appointed to take over the TRC cases. Then she read the dockets to see what she had on her plate, and that was showing in a lot of these cases major investigations outstanding. And she continued, I think, till December 2015 in that portfolio. There was an impasse with the foreign bribery after Advocate Abrams took over, that he said, I've not been relieved on my duties, I must continue to report to the OECD. But then he allowed Advocate Mkhwebe to remove the dockets from me. So what I did is I started helping Advocate Bukhar because she had no background to these. And she was particularly struggling with the Neil Agate matter, where the inquest record was 4,500 pages, only available in batches electronically on the WITS. So I started helping her there. I picked up the PEPCO 3 case the Timor matter had been closed, and then I requested the police to investigate that. And I was assisting in identifying, getting the detention files, tracing of who the suspects were, etc., until Dr. Pretorius took everything away from.
So you see, Advocate McAdam, we need to assist the Commission to understand how it was that these cases never, well, most of them never saw the light of day. And certainly in the period 2003 to 2010, I think we have a pretty good idea that a combination of executive interventions that we've discussed previously and the fact that investigations were simply not happening at that time, that certainly explains the lack of delivery through to 2010. But post-2010, we now have SAPS through the DPCI on board. And in theory, at least, cases are being investigated. But we also see what might be called as missteps on the part of the NPA, including, for example, the shuffling of you from the TRC cases to corruption cases, back to TRC cases, to foreign bribery cases. So would you agree that that kind of chopping and changing really undermined the TRC cases, and these could be described as missteps or strategic blunders on the part of the NPA?
Madam Chair, we were dealing with a situation of extreme capacity constraints. When Advocate Ackerman retired, we were left with only 4 advocates, one of whom would have to act as the head of the unit. That means you take on a lot of responsibilities on the management of the MPA, less time to actually read dockets, go to court, make decisions. And I know for a long time there was an externally imposed moratorium on filling vacant posts and creating new posts for, I don't know if this was DPSA or another department, but it was something that was imposed on the MPA. And I know as a fact that that moratorium was only lifted shortly before I retired, because it was only, despite the fact that in January 2021, I had done all the memos to employ these retired prosecutors to work full-time on these matters. The DPSA only approved in September 2019, and Advocate Anton Duplessis, the Deputy National who negotiated permission, told me it was an uphill battle. It took him, he went through hell trying to get those appointments for us. When I was removed, it was to deal with serious emergencies. The block case was a company that through corruption had a monopoly on all the rentals for the province of Northern Cape. I worked on that matter doing the investigation with the crack detective and PricewaterhouseCoopers. The reason I was doing it was because the Northern Cape office had very small capacity and nobody with commercial experience. But then a commercial prosecutor at the level of deputy director was transferred to Kimberley. He took the case over. There's a conviction against the MEC, the company director, 15 years imprisonment for both of them, and 70 million rands worth of assets forfeited to the state to go back to the companies that had been defrauded. So that was significant. The foreign bribery was no petty matter. South Africa had signed a convention to prevent the bribery of foreign government officials to get lucrative contracts. There was an assessment carried out by the OECD.
Sorry, Mr. McAdam. I hate to be rude, but we're approaching the end of the day, and we don't contest that these foreign bribery and corruption cases were pressing and needed to be prioritized. So, if I may ask you to return to the TRC cases, but you can accept, we do not dispute what you say about the urgency of all these other cases. You mentioned in paragraph 41.
If I may, the witness is dealing with what was put to him.
Mr. Banner,
Yes,
if you
if
may
I-
speak up a bit.
Thank you, Chair. The witness was dealing with a proposition that was put to him in relation to missteps and some sort of suggestion that there was something improper.
Yes.
And he should be given a chance to complete that answer
Yes.
as fully as he wants, dealing with whatever he needs to deal with, whether
Yes.
Mr. Varney wants to hear that or not.
Yes, Mr. Vani, I will allow the witness to complete his evidence in that regard.
Switch off your microphones, Mr.
Madam Chair, my involvement with these TRC cases stopped in 2014 when Mr. Katsana took me out of the whole PCRU, not just TRC cases, the whole PCRU, to do the foreign bribery. I can confirm from 2010, when Superintendent Bester tasked out the investigations, up till that point, the police were investigating. I was engaging with them, I was giving them instructions how to investigate. There were cases where I could make decisions. Unfortunately, they were all decisions to decline to prosecute, but not. So work was being done. I accept it's not ideal. There were also capacity strains on the police. Often you were frustrated about the quality of investigations, but you tried to address that by, giving guidance, fixing things. And again, if you look at the Police Start 2010 on matters that go back the 1980s, it's no easy matter to suddenly wave a wand and you've got all your evidence. So the work was done. Not to the best standard, but what we could do in the circumstances, both police and NPA.
Mr. Vani?
Thank you, Chairperson, and thank you, Mr. McAdam. That's helpful background. Chairperson, I see it's just gone 4 p.m. Would this be an appropriate time to adjourn for the day?
I think so, taking into account that Mr. Advocate McAdam is of matured years. I think this would be an appropriate time to adjourn until tomorrow at 10 o'clock.
An observation,
please.
Madam Chair. His energy and resilience, I think, surpasses most
Yes.
of the younger ones here.
Thank you.
Chair, if I may ask, what does matured age?
Your microphones are off.
I wanted to find out, Chair, that what matured age would signify, Chair.
It means you still perform like a Duracell battery.
It signifies people of your age, Ms. Moroka.
Thank you, Chair.
We are adjourned until tomorrow at 10.